Free him. Free him from the stress.
Free him from the shackles of this fucking government, bro.
Brush your hair.
Oh shit.
Free
Why
him.
you look like a sophisticated chief, Keith, bro?
Oh,
That's crazy.
nice hair.
Oh shit.
Yeah,
Yeah, that's
bye,
PD side, brother.
bitch.
That was rude.
Yo,
Appreciate that.
What up, King?
what up?
Yo, they really let me in here with a lightsaber. I ain't gonna hold you. I'm kidding. It's only a decoration. I promise. I store my homework in here. I store my homework in here.
That's crazy.
Okay. Dumb as a rock.
Shut the fuck up, Chico.
Okay, buddy. Fuck you.
Excuse me, bud. Sorry. No, you.
A lot of crop dust this whole fucking courtroom.
Excuse me.
We're sitting in front row, bitch. Come on.
What the fuck?
Yeah, tell that bitch.
You know what it is, y'all.
Damn.
Where the fuck we sit down in this bitch?
Think about sit chair.
Yeah, you gotta looking gang. We fucking go.
Bro, who's hungry? Eat.
Shit, that might be that might be me, gang. You got a burger or something? Shit.
I got you. Hold on.
Yeah, 20K.
Oh,
I got
you hoeing me now, huh? Sit
I'll tell
chair.
you
You gotta
what.
do sit chair.
Ain't shit for around the city, bro.
Sit chair. Yep, turn around like that. Sit chair.
Okay, is everybody ready?
Damn, nigga.
Yes,
Pimp
sir.
down. Pimp in distress.
Oh shit.
He said
Alrighty. Court is now in
It's
session.
cool. I'll
The
watch this
criminal
court case
trial
like
of
this. Fuck it.
State v. Jones.
Watch it for only 5 minutes.
The prosecution and
Cool.
defense are present. We are here to hear the facts and arguments regarding the charges brought against the defendant. Both parties will have the opportunity to present their case,
Yo, officer.
introduce evidence, and call witnesses to testify before this court. I
Pimp
expect
down,
all
man, pimp down.
participants to conduct
Yo, we need
themselves
EMS.
with
Pimp in
professionalism
distress.
and adhere to
Pimp
the
in
rules of
distress.
this court. With that said, we will now proceed with the opening statements. Prosecution, you may begin.
Shit, who's
Good
getting
evening,
locked up?
ladies and gentlemen. Today you will hear the details of the case that involves not only serious violations of the law, but actions that threaten the safety and stability of our community. The defendant stands charged with 4 very serious crimes, consisting of the following.
Oh shit. They getting active out there.
Oh shit.
Oh my god.
Yo, King, that's PD side.
You gotta say that on the radio, by the way. Huh?
Hey, homie, sliding.
And Capone, if you'll walk forward to the stand.
Oh, I'm right here. I'm right here.
Why are you on the floor?
I'm bleeding out.
Stand over here.
I'm hungry.
Capone the stands in the center of the
Starved to
benches
death.
to where the judge is at.
Fuck's it, you missing
Remember
this
to
bitch.
talk over radio.
Hey, watch out, bro.
Yeah,
You trying to
radio
scoot past
fine.
my bitch and shit, dude?
He said, excuse me.
They're on radio.
That's cool. 10K to pass by her.
Well, you dead, so ain't nothing you can do.
Hey, man, just wait till I get up, motherfucker.
Yeah, look at her slide over like a nice
Ah.
lady she is.
No problem you want.
Little bitch. She ain't shit.
Good evening, ladies and gentlemen.
Excuse me.
Today
No,
you will
don't
hear
leave
the
me.
details of a case that involves not only serious violations of the law, but actions that threaten the safety and stability of our community. The defendant stands charged with 4 very serious crimes, consisting of the following: criminal possession of a weapons class 1, evading police, possession of a controlled substance, and possession of a Schedule 2 controlled substance with intent to distribute. The evidence will follow that the defendant knowingly and illegally possessed the firearm, a weapon of great potential danger. The firearm was not in the defendant's possession. Of any lawful purpose. It was carried with intent to commit further crime, with no regard to the lives it could impact. The law is clear. Guns in the hands of individuals without legal justification are a threat to us all, and the defendant chose to carry this weapon
Gentlemen,
in blatant
let's keep it down
violation.
back there.
But it does not stop there. When law enforcement attempted to apprehend the defendant chose to evade capture, fleeing from the police in the reckless attempt to avoid responsibility. This is not a simple act of resistance. It is a deliberate and dangerous decision to avoid accountability and further dangers to the public.
Thank you.
And if it weren't enough, when the defendant was eventually apprehended, officers found controlled substance in their possession. Not only did the defendant have illegal drugs on their person, but they possessed a Schedule II controlled substance which they intend to distribute. These drugs are highly addictive, with no legitimate medical use with a prescription. The defendant intended to distribute them to others, contributing to a very real and devastating drug crisis in our society. You will hear facts, you will see evidence, you will understand the defendant's actions were deliberate, reckless, and criminal. After the conclusion of this trial, we will ask that you hold the defendant accountable for the serious crimes.
Objection, objection. We hate niggers and faggots. Shut your bitch ass up. We hate niggers and faggots. You fucking pussy. Ah, you fucking faggots. Ah, you fucking faggot.
Up here.
Can I squeeze in here, roll it? Oh, my bad.
Give me up. What the fuck? Everyone's dead. Oh my god.
No, they were just sleeping gas. It was sleeping gas.
Yeah, sleeping gas.
Get off my dick. They're all trying to rob me. Help!
Do you have a gun on you?
Help, officer. Take these handcuffs off me. I don't even know why I'm handcuffed, gang.
Why is he handcuffed? Did someone here handcuff him?
Yeah, for no reason, please.
Okay, so then
people
we
down,
don't.
Yeah, just take him outside. Take him outside. Don't even do it here. Just take it outside and handle it.
Don't rob me, gang. Don't rob me. What the fuck? I've been in here. I've been searched, bro.
Hey, Captain. Commander.
Yes, sir.
Should we funnel everyone out, then funnel them in one at a time, fill in from the front?
Everybody that's inside is okay. I'll notice that any more coming in from the outside. Go ahead and handle them.
Alrighty. Yeah, sounds good. Excuse me.
Damn, bro, right in the middle of our opening statement.
I was curious why there was no one on channel 3.
Yo, hey, stop forcing RP. Move.
On channel 20.
bro, the blueberries need to watch out, bro. Excuse me. Get out.
Is that all OPD? Who the fuck's that first one?
Move, Smokey. Move.
All right, gentlemen, you're gonna fight or you're taken out.
Let me get through real quick.
Tell him get out my way.
No one's in your way.
Start moving this dude out of here, man.
All right.
Everybody get into the rows. Take a seat.
It's harder than you realize.
We're gonna leave the center aisle clear for people coming in.
Can somebody give that guy a cough drop so he understands that he's like.
Yeah. Why you came up a complete jackass? I hate people.
Yo, Christopher, shut up out there, bro.
Hey, Capone, you look great up there.
Thank you, sir. I try, you know.
Hey, stop trying to fight with people on the Kirk case.
Yo, don't know what to do.
The Kirk case? Alright, let's clear the radio. Jermaine.
Yeah.
What's the radio?
20.
Is
Alright,
that?
I'm gonna give everybody in the courtroom 1 minute to find your seat. Past that, you'll be held in contempt.
Take a seat, everybody.
I love you, Lawson.
Let me
It was weird because I pulled up because I saw all our
Like
like
your
blue
last
things.
paragraph, pretty much. I'd say wherever you read.
If you could do it, he'll stand up.
Of course, bro.
Do we not have an attorney?
Yeah, I was just trying to get everybody to quit moving around because a while ago when Capone was trying to give opening statements, 30 people were running around.
Who's Corey?
Oh yeah, let me.
Oh, you're
Rivers. Jesus Christ.
Can we go check if there's anybody else in the foyer there?
No,
Are they
we're
coming in?
getting them.
Could
I got
the-
Dilly and
could the
Alejandro.
uniformed officer go out off of the floor since he's. Can you scoot down just a little bit?
Yeah. Rivers, just stay at the back. Stay near the back, near the door. For
And
me.
shit, everyone. Okay.
Sorry, I'm just trying to manage the courtroom for you guys right now.
That good,
That's good.
All right, in the rows. Go to a row. We're not leaving the center.
I'm just trying to find a spot to sit, man.
I understand.
Excuse me, so you can scoot down.
Hey, can
Leave. It's been a minute. You're on.
Yo, get that blue guy over.
Everybody in here, put your voice boxes on.
Who's the one with the fucked up voice box?
It's the guy with the blue hat, bro. The guy with the blue hat, bro.
Hey, but can I get you to stand up?
No, it's the guy with the white mask.
Almost positive that he with the husky mask.
Yo, what?
If I can get you to stand up, please.
For what?
Come outside really quick with me.
Yo, just turn your shit to push to talk, bro.
Wait, CC, let him in so he can sit on the other side.
Put your voice box to talk.
Max, go in.
You tagging first for Charger? You tagging first?
Yeah, what the fuck?
You're getting a lot of feedback.
Who posted? Evan?
Yo, Bert, quiet.
Your Honor, we'll give them another minute, and then we're gonna go ahead and restart.
Give me 1 second, I'll check with my boys outside to make sure that everything's good. Jermaine, would you mind locking the door to entrance into the courtroom, please?
Oh,
Yeah, sure.
Very sorry for pussy. Thank you. I appreciate that.
Hey, George.
You left an officer out there. Here, come up to me, Jermaine. Real quick.
Crazy back.
Let me get the 2 officers. Here, unlock this real quick.
Damn, they got real security in this bitch.
George,
now.
they came
All right,
from me.
in.
I didn't go for them.
You guys in.
Right now, there's
I'm sure we're all
speed this all up
whispering.
and get home in time.
I can't whisper, unfortunately.
Sitting in the
I want
back
to,
this time, bitch.
but my thing doesn't work. Your muscle doesn't
Go ahead,
work?
Jermaine. Thank you.
No.
All right.
Dilly, Alejandro, you're gonna be
Or something else.
lobby
Anyone
monster.
remaining standing before the
Sorry,
finishing of
Jermaine.
the open statement will be held in
Like a good
contempt.
boy.
Alejandro, stand on the other one.
Sit down, please.
You gonna say please? You gonna have some manners today.
I just said please.
Stop fighting.
Yo,
You
shut
touch me,
up.
officers right there finna get you. You already get. Man, don't nobody want that transformer. You better watch out.
Shut your dumb ass up.
Don't nobody want that transformer, boy. I know you're not talking to me sounding like a man.
More of a man than you, bitch.
You're dressed as a female. You can't be.
That's a violation.
This is my bitch. Watch how you talk to Try me, bitch.
What you gonna do if I don't?
Hold on.
Try being my size,
I know it
Amy.
is. She over here talking.
Alright, whoever's remaining talking, let's go ahead and get him out of the
Yes,
courtroom.
sir.
Hold him to a $15,000 contempt of court fine.
Get him out of here.
Get that going, officer.
Try being my size, Amy.
Dilly.
You don't know.
Radio 20.
I'm already in it.
Perfect.
Anyone else remaining standing will be held to a $15,000 contempt fine as well.
How am I going
That
to
for?
I don't work here.
Officers.
Excuse me,
That for
officer. Can you please
excludes
get this
off.
man? He keeps talking to me.
Yo, this guy's still echoing, bruh.
Yes, he's escalating the situation. I'm not even doing.
No,
it.
he's
Can we get this guy out? Get him out of here.
Which one?
Yeah, this guy in the blue hat, white shirt. Go ahead, just kick him out. He's not.
No, it's not the blue hat, white shirt. It's the man in the brown shirt right here.
Rivers, go ahead and just get him out.
It's him right here.
Officers, I'm going to ask you one more time, anyone remaining standing, to go ahead and
Sir, I go
file
ahead.
them in
Hey,
contempt
you
of
two right here in the front. Y'all gonna have to sit
$15,000
down. Or
fine.
you're gonna have to be escorted out.
Yo, I'm just standing. I'm not gonna do anything.
Take a seat. Not gonna
It's
tell you
not about
again.
sitting.
Take
The
a
judge told you to sit down.
Everyone
You're gonna
sit
be
down.
charged with a $15,000 contempt.
Yo, Larson, let me stand up, bro.
What, Jamal? What?
There's no more seats left.
Set your butt
Bro,
down.
there's a seat over here. There's a seat on the other side.
I'm gonna escort you out fine you. Take a seat, both.
We was trying to wait for him to get, talk
Nope.
to that dude. Sorry,
Alright.
sir.
Yep. Go ahead there. Take a seat.
Hey, if you guys wouldn't mind taking a seat and quieting down, I can't cook PD until they get to say their opening piece. Thank you guys.
Oh god, this shit's gonna be easy.
Jermaine got this shit on lockdown.
We're going to speak over the
Okay, Mr. Capone, you can continue.
Alright. I'll just kind of give the last bit here. Commander Capone again here. You will hear facts, you will hear the evidence, you will understand the defendant's actions are deliberate, reckless, and criminal. One sec, we got somebody yelling back here. Come on, give us 1 second. Open the door.
Kill this bitch. She don't make me tacos tonight. I swear to
I
God.
want to
She don't
say
cook me
something
food tonight,
on
I'm killing
video.
her
And I
ass.
quote, he's
Killing
gonna
her.
kill this bitch
There you
if she doesn't make him tacos. Thank you. We appreciate that. Thank you. Y'all didn't hear that. Don't worry.
I heard that. George, how much for you to dare me to be like, I'll pick up on
Okay.
Yo, shut
again,
up.
Commander Capone here. You will hear facts. You will see evidence. You will understand the defendant's actions deliberate, reckless, and criminal. At the conclusion of this trial, we will ask you to hold the defendant accountable for the serious crimes. The law is clear, evidence is overwhelming, and justice must be served. Thank you.
Mr. Jermaine?
Yes. Your Honor, members of the court, fine citizens of the state in San Andreas, you will find throughout the court case that the evidence shows that my client's rights were violated, and that as such, the evidence obtained from the violations of the rights is inadmissible, and therefore the charges they're pressing on them cannot be applied. And furthermore, that they have, throughout the whole entirety of the arrest, the interaction, the processing, and the court case here as well, have engaged in several violations of law, statute, and common practice, as well as clearly established law and case law, which makes their case completely inapplicable, and that the misconduct of the officers goes beyond just the negligence that they've demonstrated so far up until this point, but that the arresting officer, Hank Hankson, lied and falsified about the events of the statements clearly in the report, a signed government document, and therefore has committed a crime in and of himself, perjuring himself as to the events that happened, and furthermore misled the lawyer during the discussions in an attempt to obstruct the justice and misconstrue the facts of the case. The burden of the proof is on the state, but you will find that the only crime that will be proved throughout this case is that Detective Hank Hankson, otherwise known as Detective Popseye, committed the crimes of obstruction of justice and of perjury. And with that, I turn it back over to the prosecution, Your Honor.
Capone,
Okay.
Prosecution, may present your evidence.
Yeah, you got it. Go for it.
Prosecution, you may present your evidence.
Hey, Patel.
Hey Capone, I don't know if anyone told you, but you're the prosecution.
Wait, what?
Come on, bro, lock in.
Hey Capone, it's your turn to present the evidence. Oh, there he is.
We're good.
Door open.
If anyone else makes an
Take
outburst, I'm
standard.
putting you in post and taking you out.
May.
Yo, is this kangaroo court or something, bro? Like, what's going on?
Objection, Your Honor. The prosecution has been continuously submitting evidence after the discovery deadline at 8 for the past 23 minutes. I will have to motion to suppress the pieces of evidence they've submitted at any time stamp at or after 8 p.m. Central Standard Time as the listed discovery deadline.
Overruled. Continue. Alright, Your Honor, evidence provided here stating on Exhibit 12 does show that Mr. Hank Hankson had approached Mr. John Jones in order to question him about the explosion that occurred on February 28, 2025, sir. He did approach him just to question if he had seen anything. He was not detained at the moment, but he did, make it clear to say if you saw anyone, where do you live? After that, Mr. John Jones did start acting suspiciously, moving around. So Mr. Hank continued to forward his questions with, do you live around here? Are you from here? What are you doing around the area? At that time, that's when Mr. Hank Hankson then proceeded to call backup and get a K9 unit in order just to be around, sniffle any type of explosions due to the explosion that occurred. During that time, Mr. John Jones then proceeded to run away from Mr. Hank Hankson into an alley where an orange car was found. Of course, I do not have that license plate, but he was getting into that car. During getting into the car, Mr. Hank Hankson did repeatedly state that he was going to get tased if he would not get out the vehicle, and proceeded to turn on his vehicle, which he was then tased. After he was tased, he was then put in handcuffs due to evading detainment, which is obstruction of justice due to he was not complying with lawful order. He was then questioned after that on why he ran. He was then patted down, and on the pat down, it was a Terry frisk due to the reasonable suspicion at the time. Once he was patted down, we did find the illegal weapon, which was with the charge of the criminal possession class 1. And we also found around 20 bottles of lean.
Wow.
Lean is a Schedule 2 drug, which is illegal
That's a lie.
in the state of California.
Hey, give us the recipe.
Yep.
Oh, yeah.
That's a lie. Go ahead,
Officer Capone, I love you.
Seven right next to
Assistant counsel going to step in here. I would also like to include an exhibition on exhibit here. A second. Do we have access to this evidence since this is a court of peers? Mr. Jones, you will be held in contempt of court if you keep speaking. I was asking a valid question. Thank you. Don't ask any more questions.
So once he was patted down for the weapons on the Terry frisk, he then gave us probable cause to continue searching his pockets in order to see if he had any other illegal items, which was then found of a Schedule 2 class drug, which was the lean. Over 20 bottles of lean, which then made it the criminal possession of a controlled substance, which also made it a criminal possession of a controlled substance with intent to distribute.
Crazy they think. Officer.
He was then brought down to MRPD for processing and was then booked and fined, where he then pled not guilty.
Sudafed is mad.
Assistant counsel would like to point to exhibit 7, where prior to attempting a Terry frisk, a K9 was alerting to a substance being sniffed out from the defendant here. This is also what added to the real suspicion and then probable cause after that.
No further evidence, Your Honor.
Like to call any witnesses to the stand?
Oh yes, I would like to call up Mr. Christopher Maxwell. He was one of the officers on the scene at the time, sir.
Other side, Mr. Maxwell. Bailiff, do you know how to swear someone in?
Jermaine, you want to open the door for me, buddy?
Oh, my apologies.
Yeah.
Yes, sir, I can.
There you go.
Thanks.
Alright, please go continue to swear Mr. Maxwell in.
Mr. Maxwell, I need you to raise your right hand and repeat after me. Do you swear to tell the truth, nothing but the truth, and everything, so help you God?
Tell me. May take.
Hey, Mr. Maxwell, how you doing today? Can you run us down on the time events that transpired on February 28, 2025?
Yeah, so the events that took place
Hold up, Mr. Maxwell, I do apologize.
Oh shit.
Hey Larson, while we're on a pause, can I ask a valid question?
No.
I was going to ask if we have access to see the evidence to be
No,
presented.
not just bench trial.
Can I get the bottom door unlocked?
Yeah.
Yo, can I get the code?
Get up there.
You didn't find me. They're lying.
How are they lying?
Because
cops
You
are
may
dumb.
continue.
Continuing on.
He didn't have lean on.
Continuing
me.
on, the events that took place, we received a 911 dispatch call from dispatch about an explosion in the area of Los Lagunas Boulevard at Postal 621. At that time, Hank Hankerson, as well as Southern 7, responded to search the area, as at that time, this area is known to be a possible narcotics area for crafting said narcotics. When they arrived on scene, they found a Mr. John Jones on scene, and I was positioned stationary. Everything you've been explained with Mr. Hank Hankerson as well as Southern 7 interacting with Mr. John Jones occurred, at which point I was called in to assist with Mr. John Jones taking off. When Mr. John Jones took off, I then arrived to Mr. Hank Hankerson tasing Mr. John Jones out of the vehicle, with giving him multiple attempts to stop. Once he was tased, he was placed in cuffs and informed, and then asked why he was running. At that time, after he was asked why he was running, Mr. Hank Hankerson informed Mr. John Jones that he was going to conduct a pat-down search of Mr. John Jones, and if he was going to find anything, to which Mr. John Jones did not give any answer at that point. At that point, Mr. Hank Hankerson performed a pat-down, and in his waistband seemed to find a lump of a magazine of a firearm. At that point, Mr. Hank Hankerson removed the firearm, and at that time searched Mr. Hank Hankerson, informing him that we have probable cause at this point to search him the rest of the way. At that time, Mr. John Jones searched and found to have the items of evidence on him, and at that point was then read his Miranda rights for criminal possession of Class 1, as well as evading, as well as possession of a controlled substance with intent to distribute.
So at the time he was placed under arrest after being tased, he was under detainment, correct?
Correct. He was not under arrest until the time that a firearm as well as the drugs were found on him. After that, he was placed under arrest.
Thank you, Mr. Maxwell.
Can you hear me?
Yeah, Your Honor, can I call up another witness to the stand, sir?
Your Honor, I do believe I get to cross-examine the witness.
That is correct. Mr. Maxwell, please remain seated.
Your Honor, permission to approach the witness stand.
Go ahead.
How you doing today, Officer Maxwell?
Doing good, your man.
Obviously, it's been established you were present on the scene. Could I ask you? You're a literate man, aren't you? You're familiar with the standard operating procedures of the police department?
Yes, sir, I am.
What's the procedures around evidence collection and possession when you collect evidence off a subject, say an illegal item like a drug or a drug crafting item? What would be the process for storing that, keeping it? Do you keep it in your pockets? Do you toss it out the window? Do you put it in a evidence locker at the PD? What's the process there?
So the process there, from the time that we find it on the suspect, we then place it in our pockets to transport to the station. From there, it is given to the arresting officer at that time, and the arresting officer will then take all that evidence and then place it in an evidence stash, which is connected directly to our database within our MDT system.
I see. Would an officer ever just say continue to keep an illegal item or substance on them?
No, they would not. That is against SOP.
I see. Could I ask...
Your Honor, objection for relevance here?
I say collection of evidence procedure is relevant given that the majority of this case is based around collection of evidence.
Overruled. Continue.
I see. And you'd stated that you got a call about an explosion. Could I ask, were you engaged in any arrests or anything like that before you arrived on scene?
No, sir.
I see. So could you explain why you, Officer Maxwell, had drug paraphernalia as shown in your body cam before any search was conducted of the suspect?
I didn't. If you look...
You very much so, sir, did. Would you like to re-examine the exhibit with me?
Yeah, I could look real quick, but if I did, it was due to the fact that in certain situations, I will advise that if a suspect is to code 0, as we say.
Your Honor, again, objection for relevance.
Your Honor, given that most of this revolves around relevance, I believe what was possession in terms of illegal items already on the pockets of the officer could be relevant to the case. I've only asked my first question in this string. I don't see how an objection could be warranted before I can determine the facts of the case.
The officer is not the one that's on stand here. He's not the defense here.
Yes, but, well, actually, he is on the witness stand. I'm not sure if you saw that or not. So that is why he's being asked questions.
Overruled. Continue.
So I would like to state that I am looking through the exhibition here. My body cam was never submitted here. The body cam you were seeing in the exhibition there is from Sergeant Southern 7.
I see. So would there be any explanation for why Officer Southern 7 had drug paraphernalia on his person?
Your Honor, objection for speculation. The witness cannot attest to why another officer would have something on him.
Very well.
Courtroom, please?
Very well. I'll move on from that specific line there.
Someone please escort Mr. Jones out.
Please.
I've asked 6 officers.
All right, Officer Maxwell. So you had stated.
Keys to that door right there.
Mister, would you mind go letting him out real quick so you can continue? He's gonna keep yelling.
Yeah, I'll go let him out. 1 second, I gotta let this guy out.
Thank you, Jermaine. I've been asking 6
You're welcome.
Oh my god.
You just leave the door unlocked?
The other door can do that.
Here, I'll leave this unlocked. PD
Dilly,
can
go
unlock
out there,
the
unlock
other one.
You're fighting for your case and pass it.
Alright. I hope I get bailiff pay for this. Now, let's get on to the next point. You said you were a literate man, sir. You arrested the defendant for possession of a Schedule 2 with intent to distribute, correct? Could you please speak into the radio?
Can you hear me?
Yeah, I can hear you.
Yes, that is correct.
Okay. And what was your basis for that? What was the Schedule 2 and the amount that he possessed?
So the Schedule 2 was the lean, which he possessed 20 of. 20 count.
I see. He possessed 20 lean.
Yes, sir. The exact amount in grams I can look at, but I do not know off the top of my head at this time.
But we had 20 cups.
Lean.
Very understandable. 20 cups of lean. When subpoenaed, what was turned over to me in discovery, does not look like 20 lean was included in the discovery. Could you check Exhibit 2? Perhaps I'm missing what the lean looks like. It is a white cup with a purple bit. I see what looks like the prosamine and the other ingredient, the codeine and the firearm, but I don't see any lean in Exhibit 2. Could you check and verify that I'm not missing the lean and the turned over discovery for what was taken off of him?
Yes, you are correct.
Okay, so when subpoenaed for that, you didn't turn that information over. So that would mean it would be inadmissible now, correct?
That is correct.
I see. But you said there was 20 on there, so that's why you hit him with the felony intent to distribute a Class 2. You're a very literate man. Do you know how to get to the state law, sir, that was listed in the exhibits?
Yes.
Would you go and read 1204A and then recite what it says there to the court?
A is controlled substance, which is a misdemeanor if less than 50, felony and more of or at 50, drug trafficking if 100.
I see. And so the 50 to 100 would be the felony with intent to distribute. Now, I will admit I'm not the greatest at math, officer. By how much does the number 20 exceed 50 for the felony with intent to distribute, would you say? How much does it exceed 50? How much does 20 exceed 50, since that's what you charged him with?
30.
So 20, you are saying under oath that 20 exceeds the number 50, is greater than the number...
No. Sorry, I wasn't understanding the question. So, repeat the question.
How much... You charged him with felony possession with intent to distribute, which would be 50 to 100. And you said he had 20 on him. How much does the number 20 exceed the number 50?
By negative 30.
I'm having a bit of difficulty piecing this out. Could you tell me how that charge would be applicable if it was less than 50?
It wouldn't be.
I wouldn't. So the possession of Class 2 with intent to distribute, you're saying that's not applicable?
I would say that at this time, due to the fact of the evidence provided.
That's very understandable. Well, you were there. I remember when all of the items that were taken were listed off. He said it was 20 promethazine, the 20 double cups, the pistol, and that 31 blunts were taken off of him. Could you tell me why were 31 blunts taken off of the subject?
With compliance with the Los Angeles Police Department, the legal limit of blunts allowed is 20 max.
I see. You're a very literate man. You read that in your SOP, correct?
Yes.
Could you go to the state law to 1204B for me and go into that illegal item and substance list?
Is he allowed to take pictures in court?
No. Hey, put the phone down, sir.
And go to line 139.
Yes,
Here we
under the state law, what does it list the legal amount as for blunts? The legal amount that can be carried?
Infinite.
Infinite. And you took 31 off of him.
Correct.
Now, could you... You're very good at math, sir. Could you tell me by how much does the number 31 exceed the number infinity?
By a lot.
Oh, it exceeds it by a lot. It's a
No,
lot.
it doesn't exceed it.
It doesn't exceed it. And you charged him with the misdemeanor possession of a controlled substance for the blunts, correct? As stated by Officer Hankson?
Correct.
So, if he didn't possess what the state law says, if he possessed what the state law said was the legal amount, would the misdemeanor charge be applicable?
I would believe so at this time, yeah.
Could you repeat that?
Gentleman in the back with the phone, put it down. For
I would say so, yes.
Why would you say so?
Because due to the fact it is not a state law statute, even though it is a LSPD guideline, it is not a state law statute.
I see. So, since your SOP is a guideline, and I want to ask you a theoretical question here. Let's say the chief of police put in a statute that you could kill anyone that wore the color pink, just shoot them on sight. Would that be a legal statute to follow?
No.
And why not? Because does it violate something?
It violates. It would be murder at that point.
So would you say it violates the law?
Objection, Your Honor. Leading question.
Sorry.
Asked and answered.
Mr. Maxwell, do you believe in that theoretical scenario that SOP would violate a law? Yes or no?
Reading it now.
Could you repeat that?
Reading it now, yes.
I see. So, if your policy violates state law, what's the higher form? The policy of the municipal police department or the state law of the state government of San Andreas?
State law.
So if state law would be the higher authority in this matter, would you say the misdemeanor controlled substance would be applicable?
No.
I see. Now I want to get on to this evading charge. Might ask you, you're a very, very literate man. You've done very good with the math and the reading so far. In the exhibit is listed Hank's document. Could you go read it to refresh yourself? I'm going to ask you a question on it regarding the chase. If you want to take 20, 30 seconds to read it really quick and let us know when you're ready.
Can we have a sidebar?
All right.
Go ahead.
Yeah, Your Honor, I'd like to make a statement here. So there's a few changes that were implemented post the charges being filed here. Why are those being taken into consideration here?
I'm not sure what you mean.
Oh, and you wanna,
What are you referring to?
So at the time of this arrest and pending investigation, we were still in talks with government litigation and all that good stuff about the quantity amount, the illegal stuff that was being sold in the Strands of the city. So this information is slightly skewed.
Because...
Would you let Capone talk, sir?
Yep, go ahead.
This information is slightly skewed. Again, while we are looking at the same list here, the legal limit of illegal and legal items, this was implemented after we, talked to government and decided that, hey, this is what we're going to do as far as, like, the strands of weed and all that good stuff.
Your Honor, if I may speak my piece now, at the time of arrest, while in cells, I went and took a photograph, and it stated the same thing, and I have full body cam of this, Your Honor. This was stated the same amount that it states now, as it did at the time of arrest, and it stayed at the same amount ever since. I've checked in every single day, Your Honor. And I know it's stayed the same amount because, of course, this was adopted when the state charter was formed from another state, and it continuously, previous to that, stayed at the same amount. The amount's not changed. The information's not changed. PD simply didn't pay attention to it, even though it's listed in their SOP, and I don't see how they can expect the citizens to follow the law, but yet get out of it themselves.
So, Your Honor, I also would state too that Mr. Jermaine here stated that he took a picture or photograph of these items. Where exactly was that taken?
And where's the exhibit of that? Because there's no exhibit of that included here.
Well, now you're bringing up this point that had not been brought up into the court. This was not a relevant piece of information. And when I submitted my exhibits, I submitted this as well, and that information was contained in there. I didn't need to submit the photo because it was already in the exhibit. I took the photo at the time for my own notes.
Where did you take the photo at?
I took it and I placed it into my legal record email channel. But Mr. Larson here is the only person who can edit that. You could speak on this, Mr. Larson. Did you at any time edit the legal amount for blunts in that document?
Oh, in the illegal items, I have not.
There you go.
I've also asked a member of your high command any errors that need to be updated in that legal and illegal items that need to be updated. Open a filing on what needs to be corrected, and I can go and give you the date that your high command officer opened that ticket.
So my question still stands. Where was that picture taken from?
That picture.
I'm not asking where it was presented.
That picture was taken as a screenshot in my laptop, and the screenshot was saved. I'm not understanding.
He's asking where, sir.
My physical location, I was in the cells at PD when I took the screenshot off of my laptop.
Correct. And then the screenshot you took, which is fine. I'm not having an issue with that. Where did you take the screenshot of?
I took it of the document where it lists the legal amount for the blunts.
So the same doc that we're looking at.
This,
RP.
Yes, and as Larson has stated, it's not been edited, so it's the same information. I feel your concern's been legitimately quashed, and I believe what they're doing now is an attempt to divert me from divulging the truth from the witness, Your Honor. And I would like to stop with the distraction here and get back to my questioning for prudence of time, Your Honor.
Our issues, we're trying to make sure defense leads up with obviously the government and legal aspects of the blunts that were taken into possession. Because Larson, you can contest to this, but at one point there was a legal limit on the amount of blunts that could be held in possession of a citizen, correct?
I'm sorry, there's a commotion in the background. Could you restate that question or what you asked?
So at one point,
can I please get the people in the lobby to maintain everybody?
That nigga out of here.
Your Honor, this has already been addressed, that it's not been changed in there. This is just continuing on the same thing that's already been quashed. I want to continue with my questioning, and everyone else wants to continue with the court case. There's no point in continuing to divert time from the pursuit of justice
right?
for something that's already been addressed.
Yes, 15K for contempt.
Mr. Capone, please restate the question you asked originally.
At one point, there was a legal limit of blunts that could be held in possession by civilians, correct? That's
Prior.
I'm coming to the disagreement here. Again, I understand Mr. Jermaine's point. That his client was taken, the blunts were taken, right, under the possession limit, right, the infinite amount, right, whatever that number could be. But at this time of this arrest and all the pending investigation by the government, per the issues that we had before about how much they could have on possession, what was legal and what was illegal, trans-wise as well, this has all become a more relevant and more clear piece.
Your Honor, just because
Jermaine, let him finish.
Mr. Jermaine, do you understand how he lets you finish and then
Bailiff,
starts speaking and you keep cutting him?
Bailiff, no.
So that's where we're sitting at. Again, we're not saying that he's incorrect. I mean, his defense is correct. But we're saying that this was all unclear piece before this was after or during the time of this arrest.
So, Your Honor, it sounds like his point is something to be cleared up in the state laws after the court. We can't retroactively change the laws to suit what they thought that it should have been at the time. If they want it to be changed, they can lobby and petition their legislative representatives and the people in government to change the law. But as for the purposes of court, it's just a distraction that doesn't serve the purposes of the pursuit of justice and has no bearing or relevance on the fact that, as you've stated, that was not edited at the time. That's not been edited in quite a long time. That was how it is at the time of the arrest. That's what the law was at the point. Anything else is an irrelevant. It's meant to be made in the congressional chambers, not the judicial ones here.
Well, Sage Germain is correct in that instance, and to further answer your question, Mr. Capone, I've asked for cooperation from a high command member of your department. Anything that has been updated needs to be altered to inform me of such, and I can give you a date and time that that filing was opened, and I can show and prove to you that that filing has not been touched since the day it has opened.
Okay, nothing further. I mean, if that, yep. So nothing further then.
Okay, I'll return and resume.
Beautiful. Now that we have that distraction quashed, Maxwell, could you repeat the last question that I remember? How much does 31 exceed infinity? What was your answer to that?
By infinity. 31 exceeds infinity by none.
By none. So you would say then that the misdemeanor possession of a controlled substance charge is not valid?
Correct.
I see. And then we were getting on to the evading charge. Now, you've had time to read the report since then, so you've caught yourself up on what Hank writ in the report, correct?
Correct.
Could you tell me, what did he specifically say happened during the chase regarding warning the suspect and telling them to stop?
The suspect then decides to try to flee on foot to his vehicle.
I'm asking, what did Hank say regarding any warnings to stop or that he's being detained? Did he mention that at all in the report?
As mentioned here, the suspect is warned many times to stop evading from police.
I see. Could you go look at some of the video exhibits? I believe both present hold it, and go re-watch the part of the chase. In fact, I believe there's one from the defendant's perspective, getting arrested.mp4. Could you watch that one for me? Just the portion where you see the dog start to bark up until he gets into the car.
Your Honor, objection here. Body cam cannot be provided to be a picture.
Your Honor, I'm unaware of anywhere where that's been stated.
Sustained. Body cam's not been admissible, so rework your question.
I see. Mr. Maxwell, you've been apprised fully of the situation. And obviously you've had a chance to review any body cams that there were. Does the events that happened in regards to the warnings during the foot chase match up with what Mr. Hankson wrote down?
As of when I reviewed it, no, it doesn't.
I see. So he never gave him any warning until after he entered the vehicle to stop, or at no point mentioned that he was detained?
Sure.
I see. So you would say what he wrote in his statement is false, correct?
From when I reviewed the body cam, I would say so at this time.
I see. So would it be evading if he was never verbally detained and never warned to stop?
I would say that charge is dismissible.
I see then, because it's a voluntary interaction. So now you had the dog with him, correct? And you saw a portion of that yourself, correct?
Yes, I was able to show up on scene after they had successfully detained.
I see. And as far as the dog goes, are you aware of what the reason was that he had the dog sniff him?
I believe due to it being a high drug-fested area.
I see. So because he was on and around a drug house, that's why he was sniffed with the dog?
Correct.
And the dog alerting is what gave rise to suspicion and even probable cause in the mind of Hank and you and...
Objection, Your Honor. The officer cannot comment as to the state of mind of Officer Hank.
Of course. So, in your own opinion, do you feel that the suspicion and probable cause that Mr. Jones had committed some kind of drug-related crime came solely from the dog alerting?
I would say so. When the dog alerted, at that point, that is when the suspect, John Jones, I believe, began to take off.
I see. And so, because the dog alerted, that's when it was decided to run after him, and then you attempted to detain him while he was in the car, based on the dog's alert?
I believe that is what Mr. Hank did, yes.
I see. So, if the sniffing by the dog wasn't legal, would that then make the detainment...
Objection, Your Honor. Speculation and leading question.
Alright. Let me ask you, Officer...
Sustained.
Let me ask you, Officer Maxwell. It was also stated in the report, I believe, that there was an explosion and that there was a fire. From your own personal observations, was there an explosion or a fire present on the scene?
I will inform. So I did not personally see it, but what I will tell you is that we are informed by dispatch when an explosion occurs in that area.
I see. But the dispatches aren't confirmed call-ins, they're just anonymous reports from the public, correct? Someone thinks they hear an explosion or a gunshot, that's what the call-in is, right? That this dispatch is reporting that there's been a call-in about that?
Correct.
I see. So you would say it's an unverified phone call since you don't know the person or their credibility?
I would say so.
I see. And you're aware that phone calls, unverified phone calls, don't give rise to probable cause, correct?
I do.
I see. A search of the residence where the unverified phone call came in about the explosion was conducted, and since there was no probable cause, why wasn't the warrant used to search the premises presented on discovery?
Objection, Your Honor. Again, the officer was not present during the search, cannot comment on this.
I believe he can, since he's been involved specifically in the legal process here, and that he can speak as to the effect of the warrant, because that would be in regards to the scene itself, not specifically actions that happened before he was there. This is in regards to the warrant, not specifically the searching.
Overruled. Continue.
So why would the warrant not be submitted in discovery?
I believe at that time, I am not sure what Officer Hank or Officer Southern seen when they arrived. As I've stated before, I was a standby unit in case something went down, and I was not there personally, but I am not sure if Officer Southern or Officer Hank seen fire or heard an explosion, but what I do know is that at that time, they might have, and that's why, but if not, I'm unsure why that was not placed.
I see. Well, now what I have to consider here, if you performed a search of the premises without a warrant, which is not present in the discovery. What right would that violate? Are you familiar with constitutional law?
Objection, Your Honor. Leading question.
I don't believe it's leading. I'm not asking specifically. Thank you.
Understood. That would be a break of their Fourth Amendment.
Of the Fourth Amendment, I got you.
I'm sorry. Yeah.
Yeah. And that's in regards to searching, correct?
Yes, that is in regards to search and seizure.
I see. So to recap before I finish up with you here, all of the charges, in your opinion, would be invalid due to all the circumstances that we've discussed, as you've stated previously? Could you repeat that?
Yes, that is correct.
Okay. And other than you, are there any officers that were present on the scene that are present in court to testify today?
Yes, sir. Officer Southern 7.
Ah, what a beautiful man. I'm sure he'll be up next. Your Honor, I think the witness has pretty well argued my case enough for me. I think I'll let him off the stand. I'd like to see Mr. Southern up here.
Okay,
Of course.
Prosecutor, would you like to rebuttal?
Sorry, repeat that?
Would you like to rebuttal?
Yes.
You may approach the stand.
Thank you, Your Honor. Alright, Mr. Maxwell, I got a few short questions for you here. Now, when the K9 alerted to there being potentially a substance on the individual, and the individual was then patted down, do you believe, right, with a Terry frisk being performed, that as of that point, that illegal possession of the firearm is a valid charge at that time?
Objection asked and answered. This witness already stated that all of the charges were invalid in his own opinion.
Sustained.
Go ahead, Maxwell.
To continue what you're
Oh,
saying.
sustained. Oh, sorry.
Yep.
Okay, let me ask you another question then. Do you believe the Terry frisk was lawful?
I do believe the Terry frisk was lawful due to the fact that shown via body cam, Mr. Officer Hank.
My apologies.
Okay. Officer Hank did inform the suspect, Mr. John Jones, that he is performing a pat-down search to see if there's anything to note, and asked him if he had anything. At which point he performed the pat-down and found a bulge in his waistband, which happened to be a firearm.
Okay, and the K9 sniffing the suspect, right? The individual, sorry. Would that be enough at that point? No suspicion over probable cause?
He was breaking up for a second. Could he repeat that?
Yeah, could you repeat that?
So the K9 sniffing the individual at this, would that make it enough for reasonable suspicion for that Terry frisk?
That would at that time, yes. That is correct.
Okay, no further questions, Your Honor.
Okay, Mr. Maxwell, you may return to your seat.
I'll rebuttal with Southern.
Bro, hold on. Let me take it. Oh, yeah, you
Prosecution, would you like to call another witness to the stand?
Yes, prosecution would like to call Mr. Southern 7 at the stand.
Go for it. You don't ask the question.
Taylor?
Raise your right hand as I'm doing, sir.
Speak over the radio.
Raise your right hand as I'm doing, sir. Alright, Sergeant 7, do you swear to tell the truth, nothing but the truth, so help you God?
Yes, I hope you got.
Alright, can I approach the stand?
You may.
Alright, Mr. Southern 7, would you state your occupation, please?
Yes, I'm a sergeant with the LSPD.
Alright, do you recall the incident that took place in regards to this case?
Yes, I haven't had much time to review, but I think I can recall it pretty well.
Okay. I'm not gonna ask you for a summary of what happened. I'm gonna ask you for everything transpired on scene there. What was the call that made you guys respond to that area?
Responded due to a call of an explosion and a mark on our GPS stating that there had been an explosion at that residence.
Okay. Upon arrival on scene, did you witness any sort of fires or explosions at the residence?
I was kind of lagging behind a little bit due to being hit by a vehicle previously, but Officer Hankson called out that there was a fire.
Okay, so a fire was called out at that time, correct?
Correct.
Okay, as the fire was called out, do you believe, as of that point, you have probable cause to enter the
Objection. Sidebar, Your Honor.
Sustained, you may approach.
Your Honor, they entered the residence at the same time. So at this time, I would like to motion to impeach the witness for perjury since they entered in a relative short span of time, and no call out was made until they entered the residence.
When you refer to they, who are you referring to?
Hank and Seven.
So he did not say he didn't enter at the same time. Where is he talking about?
He's saying that he lagged behind.
Right,
But
he's saying as in he got out of the vehicle after the other officer did, and he was walking slowly.
He was ahead of the officer up until they entered into the doorway, and that is the only point in which Hank entered into the building ahead of them. I believe that this is perjury and an attempt to alleviate himself from the responsibility for a false call-out, which he would have had direct knowledge of within 1 second of the call-out.
Objection on that, Your Honor. I say that, as a sworn oath, as public servants, our due diligence is to make sure that nobody's an immediate threat before we can give communications to officers that may be behind us or responding as well too. Mr. Hank was in his right thought of mind to enter the residence to assist anybody that might have been injured in the situation.
Your Honor, I must object to his objection because I believe it's irrelevant to the fact of the truthfulness of the statement, and I believe the evidence presented shows that the statement was untruthful and directly misguiding the court on the specific facts of the matter regarding the call-out in relation to his position and therefore his testimony afterward.
And you're right.
Happened?
Is the IP back?
Hell yeah. Scott?
Oh my.
I'm a
Power, bro.
Yeah, I guess y'all are screwed, huh? Just kidding, just kidding, just kidding, just kidding. I'm only gonna save the girls. You're welcome. Is there any other girls? Nope. That's it. Only the girls get to live. The rest of you are SOL chat.
I love you.
Oh, there's my other girlfriend. Yeah. Yeah, right? That's what I said.
That was some bullshit if you wouldn't have got me up. That's fucked up. I would have said something.
Appreciate you.
Hell yeah, brother.
She just guessed my pronouns, man. Oh my god.
Yeah, brother.
Yo, what the fuck going on?
Hey, what's the lane code?
Hey, is that an angel? Come talk to
Who got the lane code?
Hey, who's got that lean code, dog?
Who got that lean code?
He can TP us in the sky. I know he's got that lean code, dog.
Who got that lean code? What's the lean code?
What's the lean code? That's what we need for real. He know the lean code.
He said he know the lean code.
I was acting drugs and he ain't selling one drug.
Man, they're not gonna be able to get off this.
I don't know that thug shit.
We on that thug shit all day. That's what
Hey,
we
if I jump off, you gonna save me or what?
You're gonna die.
Hey, hold on.
Who gonna jump?
You're gonna have to walk off. You're gonna have to walk through downstairs.
You gotta help him off.
Excuse me.
Have to. That's the only way out.
I gotta get out.
I mean, she could have just teleported.
She's not going to.
Not doing a lot of shit apparently.
It's a lot.
Lord in Christ, Jesus, that's like a lot of fucking footsteps down there.
PD, the wizard.
The people from PD are making their way back to the courthouse.
No, the wizard wrecked my shit.
I need PD to let me out. I'm not supposed to be here.
Yeah. We all there's a shit ton of us that spawned at PD, but we're making ourselves back to the courtroom right now.
I'm not supposed to be here. Are we still doing it?
Can you come let us out?
Oh yeah, need out.
Yeah.
I thought there was already an officer right there.
Me and this dude, we were stuck in the air for a good minute because we didn't fall into that.
Welcome, Jermaine. How's it going?
Yeah.
Alright, my man, they're about to start the sidebar again.
Yeah,
I'm pretty
man, I need
sure.
you to move
Let's wait a few minutes. Just give everyone a chance to file back in that we need here.
Yep. Jesus Christ. We should avoid holding a case at court when we have an influx of flights.
Yeah.
In my professional opinion.
In my professional opinion, I agree.
Alright, Max, I'll go take your seat, buddy.
Okay.
Jesus Christ.
Yeah, but you know.
Where are you?
What does that even mean?
Can you move, please? So I can go in. Thank you, man. I appreciate it. I appreciate it.
Oh, and you realize just because I was under oath, I have to be honest about it.
Keith. Keith, give me a hug, bro. Hell yeah, Jamal, you're kinda... Hey Jamal, I love you, bro, but you're in the way a little bit.
I guess now that Southern's back, and I think they have all this side for. You want to restart the sidebar?
We're waiting for one more.
Wait, what did
One
we
more?
say before
Alright.
we did
Yeah,
that?
Mr. Patel. Yeah, he's on his way.
I think he is a little delayed on his recovery.
Sit down, Terrell. Stop No, it's about someone who potentially had a lean position. Bro, I spawned in, flying back in from all the wizards, and everyone was yelling, "What the lean code? What the lean code?"
Huh? Oh, you guys want the lean code? I got the lean code. I saw the body cam. The lean code is... You got it?
I think he's going right now.
Y'all still have the lean code?
Oh, I see it.
Yeah, we got it.
4362.
Yeah, I.
Yeah, Loki, what if that was right?
It is.
Old Ryan is a troll, bruh.
On everything, go up there right now. We can get another court case if I'm wrong.
Yeah, we finna blow up.
As a lawyer, I have to advise you not to publicly state intent before going to a known drug location, because that would establish probable cause.
Hey, I appreciate that, Mr. Lawyer. That's why I got you on retained.
So suspected drug location, I verified
Yeah.
one, so...
Yeah, so since I've given you all legal advice, that's like what, 20 lawyer fees, something like that.
Alright, go ahead and give
that guy just. Oh,
and
shit.
Francis a $20,000 bailiff.
Sit down.
Damn, y'all losing in court and outside court? That's crazy.
How long it take for a court case to fall apart?
Alright. Are we all here? Basically,
I think Mr. Capone
Patel.
just ran after the.
Oh no, there's Patel. So it's just Capone then.
Yeah, he just ran off after that guy.
Alright, ladies and gentlemen, if you're gonna come back to the court case, come now or the doors are getting locked.
Alright, yeah, let's lock that up, man.
Yeah, let's get it started.
I got you.
That
More
nigga
room
was
over there.
cooked after he read one sentence, bro.
I think we're good to proceed at this point. There's no other interruptions.
Mr. Main shouldn't even have to be wasting his breath at this time.
Judge,
I'm sorry. What did you say?
we're good to proceed at this point.
Yeah. So as I
Everyone
was
present?
yeah,
Yeah.
as I was stating before the winds hit, it's clear that he did not enter a significant time before Mr. Hank. He entered at the same time, so therefore his statement is not in line with the facts as they occurred, and I believe is being perjured, specifically to diminish his culpability for the unlawful entry into the residence, as there were clearly no flames present, and his point of view and Hank's point of view would be almost identical, and anything Hank could see, he would have been able to see at the same time when he's alleging a call-out to have occurred, which I will add did not occur. So, in and of itself, that's a second element that's being perjured.
No, you're okay. I think it's all.
The witness statement.
I was kind of like a little too close to
Speak up, I can't hear
Ladies and
you.
gentlemen of the
Speak
court, if you're
conversating in the back. Please be on
Can you go
whisper.
whisper, ma'am, if you're going to talk? You're disrupting the sidebar.
So, again, Your Honor, objection to refresh the witness statement. Just because there's no positive ID on anything happening, correct? Again, they were there for a call. I know that as far as Mr. Germain, he said that it's not valid. But, I mean, we end up on calls anytime, you know, that are given to us, right? We don't just go on an assumption that the call could be false or not. We do our due diligence as a sworn oath, and we investigate for, you know.
I don't believe Mr. Germain is contesting the legitimacy of the call. I believe he is contesting the legitimacy of your witness's statement, and I believe his reference is to the subpoenaed body cam, if I'm not mistaken.
Yes.
I believe that is what Mr. Germain is trying to get at here, and if that is the case, he has a point.
I would like to add that he has no exhibit showing who entered first or what the case is there exactly.
Well, given that I gave you guys plenty of leeway, and it's not expressly stated in the laws or in the SOPs that body cams aren't admissible but only photos, I'm sure since I've shown you some leniency towards me could be shown, as I would have prepared photos and audio clips showing as such, if I had been apprised of that specific fact, which is not listed in DOJ SOP or in state law, nor in any of the rules. Now, Your Honor, given that, and that we've all reviewed this here, I think it's quite clear that what he said was perjury, so I would like for you to admonish him publicly to the court, instruct him not to lie any further, and if that was done, I don't feel any fine would need to be issued outside of the standard process for perjury.
I'm sorry, could you repeat the last few sentences?
I don't think anything else would have to be done besides the standard process to be applied for perjury. So I'm not saying jail him, fine him. I'm just wanting the perjury applied to him and for him to be publicly admonished and instructed not to lie further during his questioning.
I believe, Mr. Germain, you stated it does not say anywhere in the DOJ SOPs or legal processes that body cam is inadmissible in court.
Yes.
If you refer to the DOJ SOPs under the case management, there is a term labeled body cam footage. If you don't mind reading that for me and getting back to me what you find.
If you could, Mr. Germain, could you read that aloud so we all can understand that as well?
I'll do you all a favor. Body cam footage can be submitted as evidence for warrant approval or to establish probable cause, but it is not to be used directly in court. Most evidence that is admissible in the court of law or relevant to establishing probable cause can be considered. The body cam footage will be excluded from direct use. However, 10 pictures from a body cam can be submitted in court as evidence.
Yes, Your Honor, that is correct. But since they were shown leniency, and if I had been aware of this at the time, I would have submitted the audio clips as well as the picture. Can I not be shown some amount of leniency in this for the consideration? Plus, this is not being argued specifically in the court. This is a separate matter specifically on perjury. I'm establishing that there is probable cause that he committed perjury, and I believe it even states in there that it can be used for the purposes of probable cause.
Objection to quash the statement sustained here. I mean, we're not getting any farther than where we're at, Your Honor.
I think it's quite clear that he perjured himself. All I'm asking is for him to be admonished and instructed not to lie on the stand any further.
Let him know, Jermaine.
And then defense is asking just for a refresh to our witness for the statement that was the questions that were handed to our witness, actually.
I will completely strike what the first line of questioning and the answer of said witness from the record, and we'll continue from that point forward.
And you will apply the admonishment and the instruction, Your Honor?
I will instruct him to not further lie on the stand, yes.
Thank you, Your Honor.
Your Honor, I have a question here because I'm sure he's gonna bring up that exact point that I asked. Are we allowed to ask that line of questioning again?
I will be okay with that.
If there's mutual agreement between two parties, then yes.
Yeah.
Okay, that works.
I'm up for
Perfect.
sportsmanlike conduct. Thank you very much, Your Honor.
Yeah, escort him out, bro.
Alright, Mr. 7 it is, right?
Yo, what are you doing, bro? Move out
Yes,
the way.
correct.
Move out
Alright,
the
I'm
way.
gonna instruct you from this point
my bad,
forward
my bad,
that you are sworn under oath to tell nothing but the truth, so help you God. Anything that is deemed or you are found, you will be held in perjury. Is that understood?
Yes, I would also like to add that I had not been added to any of the emails following the evidence or anything to be able to be refreshed. That is why I noted that I had not had a chance.
And Your Honor, for the public record, the perjured statements, all of the statements up until this point have been stricken.
Correct.
Thank you.
Alright, let's go back, do a U-turn here. Let me re-ask this question and let's get your answer on this, okay? So, again, you stated you arrived on scene, and everything has happened before that. Now, did you witness any sort of fire, any sort of indication of that residence? And what was the reasoning behind you entering that residence?
The reason behind us entering was our GPS ping showed an explosion at the residence as well as a call, so we were going to look for anybody injured or possibly in danger.
Okay, and upon entering this property, did you gather any evidence in there? Did you violate anybody's Fourth Amendment right while inside of this property?
While inside of the property, we looked around for anyone, didn't find anyone, and we did notice an area that looked to be a cook station, so we did take a photo, I believe.
So what you noticed was in plain view, correct?
Yes, it was right in the middle of the room.
Objection, Your Honor, sidebar.
Go ahead and approach.
Your Honor, plain view refers to something that's available from view from a public space, and the area that they're talking about is not available from view for a public space. They could only view it by entering the residence. Therefore, the witness has perjured himself a second time.
Objection, Your Honor. On that basis, we entered the residence obviously aware that we were entering the residence for dangerous situations that were called. That's the reason why we entered. So then at that time, things are in plain view of officer's discretion.
Your Honor, again, there would have to be cause to enter the residence as confirmed by the other witness. An unverified phone call in and of itself doesn't give cause to enter. Now, there was no, as they have stated, no apparent flames present nor any evidence of an explosion. Therefore, it wouldn't be plain view doctrine. Plain view would be if they're on the sidewalk and they can see someone stabbing someone in a window. That's not the case. They went in and then they saw the stuff. That is quite textbook definition, the opposite of plain view, Your Honor.
I'm gonna object that, Your Honor. Again, under the assumption of the witness here and his professional opinion, he believes that he had the right to enter that property, and in plain view of that property, while inside of it, witness what he said. So everything he said is factual up until that point.
Your Honor,
in his professional opinion.
Your Honor, plain view and view are two separate things. Plain view is something that can be seen without the conduction of a search. A search, as the witness said, was being conducted of the property. Therefore, it's not plain view. I mean, the common law and the case law is quite clear on this. Plain view refers to only things that can be seen in plain view without the conduction of the search. Once you can start conducting a search, it's not plain view. You can't search someone's backpack and say, well, I could plainly view the gun in the backpack, and this would be the same thing. A house is the same as a backpack, and the effects in it are the same as that.
So,
this is quite clear under the case law.
Again, the defense here is mentioning case law, right? When we're talking about a search of the property was being conducted for a person, not an item, not a backpack, not a closet, a person, right? And in plain view, during that search of a person that may be injured, that's what they seen.
Your Honor, I have to object to even that. It was plainly stated by Hank when he came in, and he even said the same thing to me in cells, is that when he came, he told his guys beforehand that this is a DEA ATF type stuff and they didn't want to stack bodies, so he just wanted to go in and look at it, and Mr. Seven was apprised of this by Hank. I feel to say that they were just looking for bodies is in complete violation of the standards that the Fourth Amendment sets, and is trying to dissuade simply from the fact that he's perjured himself. He's saying it as plain view. I'm not arguing the merits of their case right now. I'm arguing specifically, again, as before, on his testimony. He said it was plain view. It is quite apparent when a search is being conducted, it's not plain view. It doesn't matter what or why they're searching for, or the legality of a search. If the search was legal, it still would not be plain view. If the search is illegal, it's not plain view. Plain view is only something that can be seen, that anyone else of the general public could see without conducting a search. It's just standing, not looking in anyone, not looking in any objects, not looking in any containers of effects, not looking in any residence. They didn't stand outside and look in the window. They went inside and searched the premises, and that's when they found the cookware. The cookware could not be plainly viewed from the outside of the residence. Therefore, him saying it's plain view is perjury. This is all just textbook definitions here. I don't see why they're so contentious on this point. It's quite clear and quite plain. Now, I don't want to hammer them too hard on it, and I know what you said before, Your Honor, but I would be okay if you just, again, applied, maybe worded a little more harshly, but state plainly that in an admonishment that he's not to perjure himself, and if he does, he will be convicted in court, and not apply any fines or times or penalties relating to this perjury. I'd be okay giving him a third chance, Your Honor.
Would that not be... Again, the defense here is going with a textbook definition that he supposes that everybody that's not a lawyer is aware of. Plain view, at the end of the day, is something that he can see while he's inside of the property without...
Sidebar longer than the court.
Well,
how would that be perjury if that is, to my best knowledge, true?
Well, Your Honor, this
should not be.
All right, well, let's start. We're going back and forth here, gentlemen. Mr. Germain, what are you hoping to get out of this?
I just want you to admonish him again
not
not to perjure himself and lie on any specific facts, and to tell the truth, and to not apply any penalties, even though I know you said before that there would be, and just give him a third chance on this one.
Your Honor, to his best knowledge, he is telling the truth, and again, you can ask him that. That is quite literally what he believes he's saying right now.
For the purposes...
The question wasn't answered. He didn't perjure himself to that question about the plain view. Mr. Patel was stately asking the question until
Good boy, Ryan.
Mr. Germain asked for the sidebar up to that point.
Again, Your Honor, he did start to answer the question and answer yes. Now, the perjury would go off of what a reasonable and prudent person would believe, and I believe a sergeant in the criminal investigative division...
At the time of this case, I was not a sergeant.
What was your rank at the time, sir?
Objection, Your Honor. I was just relevance
at the time.
He brought it up.
Mr. Seven, I'm going to advise you to remain silent.
Okay. Yeah. So, and irregardless of rank, at the time, he was in the criminal investigative division, the dedicated division for investigating crimes, and any reasonable and prudent detective in the CID would know the difference between plain view and a search, Your Honor. And as that's the basis for law, I believe that should be applied here, because a reasonable and prudent CID detective would know the difference between the two, and thus 7 should be applied to that standard.
Alright, what we're going to do is strike that from the record. We're going to move forward. I will advise Mr. 7 of his final warning, and we'll get the ball rolling on this. Is that understood?
Thank you, Your Honor.
Smoking in court, bro. Explain that shit.
Yeah, bro.
Let's go. They're gonna start again. Go sit your ass down.
Alright, Mr. 7, I'm going to give you one and last final warning that you were sworn under oath to tell the truth, nothing but the truth, so help you God. If you are found perjuring yourself again, you will be held in contempt of court. Is that understood?
He already said that, bro.
Prosecution, you may continue.
Hey, Mr. 7, so you stated that you were searching searching the property for people, correct? Injured individuals.
Yes, in my best memory at the moment, that is what I was instructed to do.
Okay. And then while you were searching this property, what happened after that?
That is when we noticed, obviously, the area that's believed to be used to cook drugs. And then, as I was taking photos, I believe it was a sound or something told me that we needed to move out of the area for safety and kind of get away. Is it an area we should probably stay in? Because if it's obviously, an area for cooking drugs, it's something we should look into at a later point when we are more prepared and have the proper channels to look through. And at the time, obviously, I was still probationary, as I am now, so I didn't know what the channels were, so I needed to get confirmation from a higher up.
Okay, and as of that point, you left the property?
At that point, I believe I went outside to look for my higher up.
Okay, let's dive into the situation that you had with the individual outside. What did you witness happening outside?
When I went outside, that was when I believe Officer Hankson was getting the dog to sniff him.
Okay, under your professional opinion, why do you believe that K9 should be used in this situation?
Because suspect would be the term to use, was at a location where there was believed to be an explosion at the time.
Okay, and what would this explosion be relating to? Like, why would that warrant investigating the suspect?
We believed it could have been related to drugs at the time after seeing the, possible cookware.
Okay, and then what happens with the K9 after that?
I haven't had much time to review, but I believe he started barking and alerting on the suspect.
Okay, great. And as of that point, what did you guys do as a result of this alert?
After that, I believe that was when the suspect took off, and Hank took off after him.
Okay, continue from there.
After that point, that was when I believe I had fell behind pretty far at that point and couldn't see a lot of it until I caught up. Like I mentioned earlier, I was hit by a vehicle previously and was moving a little slow due to a hurt leg. And then I remember catching up to whenever he was trying to move the vehicle, and that was when Officer Hankson had to use not less than lethal force to remove him from the vehicle before he fled.
Do you believe him fleeing from Hank in this situation, Officer Hank, would warrant a evading charge?
I mean, I believe, after running, when you're obviously in a communication with an officer, that would be evading.
Did you witness the defendant turn on the vehicle?
Yeah, I believe he turned it on and backed up a little bit.
Hey, Your Honor, I'm going to point you to one of my exhibits here. Just give me 1 second. If you look at Exhibit 9, you can see the vehicle is turned on. The lights are on. And then if you look at Exhibit 10, the defendant is now outside of the vehicle and appears to be running. All right, Mr. Steven. So, again, I want you to continue from this point. As you mentioned, the defendant was tased out of the vehicle, and you believe, in your opinion, that he was evading.
Yes, in my opinion. Like I said, I haven't had much time to review, but I do believe after that he was then, put in cuffs. I believe he had his rights read to him, and he was, I believe, like I said, don't quote me on this. I don't remember if it was him or the other female that was with him, but I do believe he did ask permission to Terry frisk him before Terry frisking him. Like I said, I would need time to review, but...
Objection,
Okay.
Your Honor. Move to strike that statement since the witness is unsure of the happenings.
That's fine with me, Your Honor.
Sustained.
Okay. So you said that potentially he asked for a Terry frisk. Does he need to ask for a Terry frisk in this case?
No, in that case he does not.
Okay. Do you know what was recovered after the Terry frisk was performed?
Yeah, he felt a lump of a magazine sticking out and removed a firearm.
Hey, Your Honor, I want to point you to Exhibit 2 here. It's going to be the evidence locker of the case, the correct evidence locker, as the defense here as I'm not sure who provided him that evidence locker, but that's not the correct one. In this locker, you can see there is 20 methazine, 20 codeine, 20 cups, double cups, a combat pistol, 35 bullets. All right.
Objection, Your Honor. This was not provided in discovery.
Counselor, I believe it was in Exhibit 2.
Your Honor, that does that only covers 3 of the items listed. I'm referring to the other items.
Such
as? From what I can see in there, the only items present in Exhibit 2 are the firearms, the codeine, and the promethazine. Am I pronouncing that correctly?
Do you not see the white double cups?
Correct.
So you do not see it in the what he was provided or what I have provided there?
And what was provided by the discovery deadline under Exhibit 2?
Your Honor, I cannot attest to what was given to him because, again, we've been given this case and on a short notice here. That is what is currently in that locker, and that's what I provided in my exhibit.
Your Honor, their exhibit list has been edited since the last objection I made on evidence being entered into it, and I believe it would be in violation of standard court procedure to enter in evidence as they feel it's relevant. It should be entered beforehand so both sides can prepare, and I gave them leniency and given them an extra hour to prepare when we both know I could very well have motioned to dismiss and won the case off the bat, and I don't believe that they should be able to take that leniency and gain an unfair advantage over me by presenting evidence past the discovery deadline.
Your Honor, the locker was included prior.
Your Honor, the items in the locker was not included prior. Just because the locker number in there doesn't count, it has to be the items within, and only the 3 items in Exhibit 2 were listed by the discovery deadline.
Do you have proof of this, Counselor?
Yes, they have edited the exhibit list, and as you can see, the deadline was 8. They've entered in several items after that, and I believe any editing specifically of this to add items in, which I personally witnessed them do, and as I'm sure when I made objection you witnessed as they were doing, were adding items in after the 8 o'clock deadline.
Again, Your Honor, Exhibit 2 was present immediately as upon we started here.
Yes, Exhibit 2 was present. Exhibit 2 was present, but the other exhibit with the other items in it was not present. I'm objecting to the second photo with the double cups in it, not the Exhibit 2.
Exhibit 2 on my exhibit and not yours. I don't know what you're referring to.
Yes, under your Exhibit 2, it lists here the photo.
Correct, and that photo has not been modified.
The prosecution counselor to approach.
Are you referring to the exhibit that you have access to, Jermaine, does not show the double cups?
Yes, they did not have this photo present at the discovery deadline, Your Honor.
Oh, this shit needs to...
But
Your Honor, I can also show you if we're thinking
There's
that
more cyber than court case, bro.
if he's
court case, man.
intensely saying that we added things or whatever may be the case, I have a screenshot that I can provide to you that shows that it was in there well within the realms of the time.
Your Honor, given that it's been edited, unless that screenshot shows a timestamp before 8 with the photo in it. The
fair,
only way to do it is to quash, and I don't want to have to keep having sidebars over stuff. I gave them leniency, but they can't take advantage of it like this.
So the judge already overruled your subpoena, not your subpoena, sorry, your motion to quash after the 8 mark here, or the 8 o'clock mark. When you spoke, it was 8:30, if I'm not mistaken.
Well, the issue I have is in the discovery that the defense counsel has submitted is evidence case 251.
Correct.
Let people out.
In the evidence case that you guys submitted, the prosecutor's evidence case 232, showing
again, I cannot
completely
say
different items aside from the, I'm assuming, promethazine and codeine.
So I cannot attest to what happened prior to us accepting this case here. That is the evidence that's supposed to have been provided to him. Now, what was provided to him, I can't comment on that report.
Jermaine, let me ask you, the evidence case that you were provided, how and who provided that image to you?
According to Gotti, it was provided to him by the arresting officer, Hank Hankson, who provided that to him, and then he listed it in there. I believe, given that they were given leniency, given them an advantage on top of me being misled, it is almost a basis in and of itself to squash the case. Now, I'm trying to be sportsmanlike, but I'm not going to let them have an unfair advantage submitting stuff after the deadline and editing their submission, Your Honor.
All right, well, we're gonna
overruled on that board.
I mean, this would be grounds for an appeal if they were allowed to do this. This is just a textbook violation of the procedures of the court.
Your Honor, you overruled the evidence admission aspect.
May
of
I
this,
add
so
something
I'm not
here?
sure why we're revisiting this.
I'm sorry.
That was specific to photos being entered from the videos, which Your Honor is allowing. What we're speaking on now is a photo of the evidence locker, which you already would have had, in which there's no body cam already entered into the evidence that a photo could be taken of. Therefore, Your Honor, since this evidence wasn't submitted, I believe that it needs to be squashed.
You have no proof that it wasn't submitted.
May I add something here?
The issue that I have here, gentlemen, is the evidence case that the defense counsel was given was via a subpoena, which is a court document signed off by myself. The evidence in which you guys submitted does not correlate with the images that was provided to the defense counsel. Now, there's a clear difference between the two images. I do not believe that I'm seeing things differently.
No, you're correct.
May I add something here, Your Honor?
Go for it.
I do also have previous body cam of Mr. Jermaine accessing the case before any subpoena and saying that he was the one who submitted it to Mr. Gotti, I believe it is, the DA.
Ooh.
In Your Honor,
I spoke with Godair
Hold on a
Gardy
second.
and
Objection,
no, hold
please.
on. No, hold on. I get to speak my part now that he's spoken. As I spoke to you, Godair, and Gotti about, at the time I had full access and was under the impression as before that we had full access to the MDT. Now the MDT that's been submitted into evidence that I originally submitted was a photo of the very same one that Hank sent him. Now, I deleted my submission as I spoke with you and Godair about, and Godair signed off on this and was okay with it. You signed off on it and was okay with it because of the misunderstanding, and not even that, just the failure of this because no one else but me has had access in the DOJ to this. So, I've followed since then by this guideline, and the MDT report that's in evidence now was obtained through the subpoena by it being sent to Gotti through the proper channels. The one I submitted, as agreed upon, was deleted from the record in there as to not misconstrue any record in the court. And the one I submitted and the one that was submitted by Hank to Gotti are in and of themselves the same. So I don't see how that point has any relevance to theirs. I feel they're trying to mislead and distract from that point, and furthermore bog up the court's time with this.
Okay, this and the you're referring to, Jermaine, who are you referring to when you say you?
In which part, Your Honor?
The signing off on your access to the MDT and deleting whatever evidence that you submitted.
I do believe it was when I spoke to you. You were having a hearing here in the court, I believe, with Godare and Gotti, and it was sometime a few minutes after that while they were speaking privately in the office that I spoke to you about.
Yes,
And
yes, I know
yes,
what you're
so
talking about.
you recall that. And then I spoke to Godare, I want to say maybe 20 to 30 minutes later on the matter, and then that's when you communicated to me by email, because it was unclear at that point what we were going to do. And we came in and spoke again in front of PD, and I told you that I had spoken to go there and that we decided and agreed to go on this, and you said that sounds fine. And since then, I've not made any access to it as agreed
to
upon
clear,
until it can
alright,
be...
So to get the ball rolling, let's not hold this up for too much longer. The evidence case 251 was evidence submitted to you via Mr. Gotti through the subpoena.
Yes. And if you scroll up, you
And
can see him submitted.
prosecution, the evidence that you submitted of evidence locker to
Sorry, your voice you cut out there. Hunter?
I'm sorry, I had to go back. In the evidence locker case 232 that the prosecution submitted, what is your source of this?
That is the actual case number and evidence locker assigned to this case number.
And where do you see that at?
That is in our evidence files here. You open up the, I'm not sure if you have access or not to our cases, but you can see that in the case.
So it's not from the body cam?
Okay, so this is what we're gonna do. We're gonna continue this. I'm gonna sustain the objection. The evidence locker that the defense counsel obtained through a court document is what he received. So we'll sustain the objection and continue moving.
So we're supposed to use the incorrect evidence locker then? The case?
Well, if you are referring to that point, you are saying that your officer Hank Hankson submitted the wrong evidence locker.
We have no proof on our end right now that we submitted this, so I cannot attest to that.
I'm not responsible for their attorney or their officers, Your Honor, and I've been more than fair to them, I think. Now, could we please continue this before everyone leaves?
Yeah, let's go ahead and continue this.
So you want me to continue with that evidence locker then?
Yes.
Okay, no problem.
Tell your fuck, buddy.
Okay, prosecution, you may continue your line of questioning.
All right, I'm gonna restate what was discovered. We have 35 promethazine, a Walter, and then 5 codeine.
How do we go from
Mr. Seven, the drugs that were discovered on scene, do you believe that these were legally obtained?
No,
Was the search legal at that point?
I believe that it was a legal search after finding the firearm. Obviously, we have to make sure he's not concealing anything else that could harm us.
Okay, so after finding the firearm, you said that the search, in your opinion, is legal, correct?
Yes, in my opinion.
And what would be the probable cause there for doing that search?
Or having a legal firearm.
Are you aware if the defendant possesses a weapons license?
I believe, like I said, I haven't had time to review, but I do believe he was asked if he had a license, and he responded with no.
Your Honor, I'd like to point to Exhibit 13 here. This is a locker. This is a photo attached of our logs here that would state whether the defendant possesses a weapons license or not. What I can say here is that it does not have a weapons license, and there is no weapons license attached to this profile. Okay, and then what happened after these drugs were confiscated off the individual?
After that, I believe he was put in Officer Maxwell's car and brought to the station, while the other person that was with him was kind of questioned.
Okay, and at any point in time, he exercises his right to an attorney. What happened there after that?
Yeah, I believe he asked for an attorney once he was brought down to the station.
Uh-huh. Sit down, I'll tell you after.
Okay. Your Honor, I have no further questions at this time.
Oh, Your Honor, I most definitely want to cross-examine the witness.
May approach.
How are you doing today, Mr. Southern 7?
Good.
That's very good. Could I ask you, are you familiar with Exhibit 2 that was submitted through the subpoena to the defense by the state?
No, I was never given access to any of that.
I see. It contains a firearm, some codeine, and that Promazlino, whatever it's called. I'm not a doctor. You're familiar with the items I'm referring to, yes?
I believe so.
I see. And you're familiar with ID 251, correct?
No, I haven't looked at any of it.
Are you familiar with Locker 251?
No, like I said, I haven't looked back to check any of it or looked at any of it.
I see. Your Honor, could we communicate this exhibit to the witness here?
Yes.
If I believe the prosecuting attorney would have the easiest time communicating that exhibit with those.
Stand by.
Thank you.
The image has been provided.
Thank
Okay,
you so much. Let me know when you viewed the image, sir.
Yes, I see the image.
I see. What's locker number are the items in?
251.
251. And how do you decide what locker to put items in?
It is attached to their case.
And what was the listed case number for this arrest?
I'd have to double check.
Feel free. Feel free.
I believe it's 232.
I see, and 251 and 232 are the same numbers, correct? It was put, right?
No, they're not the same number.
So the evidence submitted is from a different locker number corresponding to a different case number?
I believe it's always like that. The case is just inside of the. I mean, the locker is inside of the case.
I'm failing to understand what you're saying though. You say you put it in the same number as the case, correct?
It's when you are inside of the case. It is already inside of there. It's not a physical thing you go find.
I see. I got you. So, could I ask you, to the best of your knowledge and having received your 2 admonishments, is the exhibit here that was presented the correct exhibit for the evidence?
I was not the primary arresting officer, so I would have no idea without have seen it before.
Well, do you have any knowledge at all that you've witnessed that would lead you to believe that this was not the correct evidence that was submitted? Keeping in mind,
Your Honor, speculation.
Your Honor, I don't believe I'm asking him to speculate. I'm asking for an answer based on his direct knowledge. And I believe that we both know he has direct knowledge to the answer of this question. And I would remind him of his 2 admonishments and very much so like him to answer the question. Is this the correct...
Continue, Counselor.
Is this the correct evidence, Mr. Southern, keeping in mind your 2 admonishments already?
I mean, as far as I would know, other than hearing more at the time, then I believe this is correct.
So you're saying under oath, with all the knowledge that the court knows that you have, You're saying this is the correct evidence?
I'm saying that I would not know if it was correct or not.
I see. So, if you can't attest if this is or isn't the correct evidence, and the only other witness for the state has attested that he doesn't believe that the evidence would have been correctly collected, do you believe this evidence can be used for the purposes of your investigation without an affirmative knowledge?
I believe that's something that would have to be questioned to the, higher up officer that made the arrest.
Well, I am asking you as the most knowledgeable officer of the scene who was present at the scene, present during the processing of the evidence, if you do not affirmatively know the chain of custody of the evidence, and the other witness has already dissuaded the validity of the evidence, do you believe it can be used for the purposes of your investigation or trial?
Objection, Your Honor. Speculation. We're going off of 5 ifs here at this point.
Your Honor, I don't believe it's speculation because I'm asking his personal belief on if evidence that he doesn't know the chain of custody or validity to can be used. As an officer, he knows about evidence processing and preparation for trial, and I believe he has expert knowledge on such subjects.
Mr. Patel, could you restate your grounds for the objection?
We have a whole line of ifs going on here. We're at maybe the 5th one at this point. That's where the speculation is coming in here.
Your Honor, I don't believe I'm asking if. He quite clearly stated he did not know about the validity of the evidence. I'm asking him, since he doesn't know the validity of the evidence, and since he doesn't know the chain of custody, and since the other witness dissuaded the validity of the evidence, if he believes it can be used for the purposes of an investigation or trial, I believe that's subject to his expert witness knowledge.
Overruled.
Thank you. Would you please answer the question? I can restate it if you need me to, Mr. Southern.
Yeah, I'm good. I mean, kind of like I previously mentioned, without being the primary officer or knowing or having spoken with the primary officer, I wouldn't be a part of the chain of custody, so I wouldn't know what it was.
I see. So what you're saying is there's no validity or verification of the chain of custody.
Objection, Your Honor. That would be opinion here. The officer would not know that.
Your Honor,
and again, the whole situation was speculation to begin with.
Again, Your Honor, as the witness, I'm asking to his knowledge. To your knowledge, Mr. Southern, is there a verification of the chain of custody?
Overruled. Continue.
I mean, to my knowledge, the arresting officer is supposed to put it straight into the case.
I see. So, to your knowledge, again, I'll re-ask the question. You have stated that you were not sure of the validity of the evidence. I'm just asking you, quite clearly, to answer the question based further on that testimony that you gave. Do you or do you not know if there is validity and a chain of custody for the evidence?
I would not know without seeing more of it.
I see. And are there any other persons present besides you and Officer Maxwell who already attested to the invalidity of the evidence, who could speak on the validity of the evidence, who was present at the scene or during the processing?
No, Officer Hankson would be the one to question about that.
Is he present for us to question?
No, he had a pass away in the family.
Understandable. So since he is not here, and since Officer Maxwell has already dissuaded validity as the validity of the evidence as being invalid, and since you're saying that you cannot attest to the validity of the chain of custody, there is no proof of a validity or of a chain of custody of the evidence, yes or no?
Sorry, repeat that real quick for me.
Since Officer Maxwell has dissuaded the validity of the evidence already, since Officer Hank is not here to testify, and since you are stating under oath that you do not know of the chain of custody and you do not know if the evidence is valid, does the court have any evidence that the Exhibit 2 that you've been shown that's being presented has a chain of custody and is valid? Yes or no?
I mean, like I said, without speaking with the officer, then no, I can't claim anything.
Perfect. Your Honor, based on both witnesses' testimony to the unproven chain of custody, I would like to motion to quash the Exhibit 2 evidence for the gun, the codeine, and the promethazine.
Approved.
I see. So, Mr. Seven, with that gone, that would be all the possession charges out the window. That only leaves the evading. So let's get on to that. Are you aware at any time when the suspect, and I will preference for the next few questions, this is all before he gets into the vehicle. Are you aware at any point when you or any other officer identified themselves to the subject?
I would not be aware without reviewing evidence I haven't had a chance to review, like mentioned.
Alright. Now, could I ask you, you were in civilian clothing at the time, correct, like what you're wearing now?
Yes, we still clearly had a badge on our chest displayed and a holster as well displayed.
I see. And are you aware of any time at which the subject was told he was being detained before he entered the vehicle?
Like I said, without reviewing, I don't remember exactly what second words were said.
I see. So, you're not aware at any point before entering the vehicle that the subject was told he was being detained?
Objection asked and answered.
Yes, Your Honor. So, are you aware at any point when the subject was ordered to stop or anything along the lines of being given a command before he entered the vehicle?
Like mentioned, I haven't had a chance to refresh, but I do believe Officer Hank said that he was get told to stop.
I see. And he says that in the report, correct?
I haven't had a chance to review any of that.
I see. You said you were injured at the time and lagging behind. Are your statements going after a first-hand account of witnessing it, or based off the report that Hank submitted saying as such?
Based off what I was told by Officer Hankson and the bits and pieces I witnessed.
I see. Your Honor, I will have to motion to strike the statement there, since it's based on hearsay of a person not present in court who could testify to what they said.
Approved.
I see. So, without any proof that he was ever told he was being detained before he entered the vehicle, and without any proof that he was identified as officers, and without any command being given, would it be evading or just free movement if he's not been detained or told to stop?
I mean, I would still consider illegal questioning if an officer is speaking to you who clearly has a badge on his chest. I mean, you can identify that with plain sight of your eyes looking at it.
So it's your opinion that an officer simply speaking to someone constitutes a detainment?
Not a detainment, but it doesn't constitute someone running away while questions are being asked.
I see. So in your opinion, a detainment wasn't constituted just by him speaking to him?
I would have no clue without looking at the legal definition of it.
I see. Well, could I ask you further in regards to this chase here? If he was never told he was... Sorry, let me rephrase. Since there's no proof that he was ever detained or anything along the lines of that, and there's no proof of him being given a command, before he entered the vehicle, would it be evading or free movement simply to move away from an officer that he was speaking to without being detained?
Well, I would say that even if it was free movement, once he got into the vehicle and was warned and still continued to try to move the vehicle, then that would still be evading.
I see. So, at no point, in your opinion, did he... Sorry, at no point, as it's been shown to be proven, did he evade before he got into the vehicle?
On the evidence I have been able to look at, no.
Okay, so the evading only occurs, in your opinion, after he gets into the vehicle. What do you feel is the time frame between when he is given the command after entering the vehicle and when the taser shot goes out?
I would have no clue without reviewing.
I see. Could you give a rough estimation? Would you say it's maybe like 2.32 seconds, maybe 4 seconds?
Your Honor, objection asked and answered.
I see. So you're not aware...
Sustained.
All right, so you're not aware of the time frame. How far did he evade in the vehicle?
Like I said, I haven't had a chance to review, but I believe he backed up until he got to Officer Maxwell's car.
I see. How far did he back up?
I would have no clue without reviewing. I don't remember the exact distance from a few weeks ago. There's a lot of cases we deal with.
What's the definition of evading? What would you say it is?
Attempting to flee.
Attempting to flee. I see. And how would you prove someone's attempting to flee? Would they have to gain a significant distance away from you? If someone, say you're detaining someone, would them stepping, say, simply 2 inches to the right constitute fleeing?
No, but I would say getting in a vehicle and attempting to move the vehicle would definitely be evading.
What if they're already in the vehicle? As you stated, there was no attempt at evading as provable and to your knowledge before he got in the vehicle, so that statement would be invalid into the purpose of this case, correct?
Sorry, repeat that. You cut out a little bit.
Since you already stated that there was no evading attempt as provable into your knowledge until after he got in the vehicle, that statement of attempting to get into a vehicle constitute evading would conflict with your previous testimony, correct?
Well, I would say that getting into the vehicle wasn't the attempt to evade. It would be the attempting to leave in the vehicle.
I see. So it's the attempt to leave. Now, for the purposes of evading, is moving 2 or 3 inches enough movement to constitute evading? Or I'm sorry, that's already asked and answered. You already said a few inches isn't enough, correct?
I mean, it would depend on the circumstance. I mean, obviously in a vehicle, if you're in park and you begin to start moving at a traffic stop, obviously an officer is going to run to his car and get in and prepare to chase you.
I see. But if they never actually move the vehicle more than 2 inches, would that really be evading?
I mean, we would have no way to know how far he was planning to go from what I remember.
I see. So do you make arrests on what you think someone might have done or what they actually did?
They actually did.
What they actually did. Thank you very much. Thank you very much. Now, I have a few last questions to ask you. The word of the officers have been quite heavy and present as the main parts of this case. Could I ask you, in your opinion, do you deal with a lot of character and a lot with people's word on the street when you're investigating crimes?
We obviously listen and try to see what's factual and what's not factual.
Yeah. So you're good at discerning what words and characters would be more credible than others, correct?
I mean, not always. Everyone lies. It's you gotta try and figure out the truth by finding evidence behind it.
I see. But someone who hasn't been known to really lie would be more credible than someone who's been proven to have lied?
I mean, to me, I would still look for evidence either way.
I see, but just based on that, would someone who's not been known to lie be more credible than someone who's been known to lie?
Objection, Your Honor. Relevance?
I believe it's specifically relevant, and if you'll allow me a few questions, Your Honor, I can establish this.
Overruled. Continue.
Like I said, I mean, for me personally, in my belief, I still look for evidence either way. I don't establish credibility to anyone, because the situation can always be different.
I see. So if you only had the knowledge that someone had previously lied before and that someone else had not lied previously before, which word would be more credible? The one who lied or the one who didn't lie?
I mean, for legal purposes, I can't take either word until seeing some kind of evidence to back it up.
Well, if there's evidence that the person lied, who would you say is more credible? The person who's been evidenced and proven in court to have lied, or the person who's not been proven at all in any capacity to have lied? It's a simple question. Please stop evading, sir.
Not evading it, you accuse me of perjury, so I'm trying to make sure I don't answer anything without having 100% fact.
Of course.
It would be the person who's not been found guilty of lying.
I see. Could I ask, has it been proven in court, as you've been present here, that Officer Hank perjured himself and lied in his police document?
Like I said, I would have no way of knowing. At the moment, I haven't reviewed anything.
I see. Do you not, could I ask, Your Honor, for the record of the court, was Officer Hank proven to have lied in his MDT report, specifically during, and as proven, the testimony of Officer Christopher Maxwell?
I'm sorry, restate that?
For the recollection of the witness in the court, previous during the testimony of Officer Christopher, it was established that Officer Hank had listed false things and perjured in the police report, correct?
Objection, Your Honor. I don't see where this was established.
Again, that's what I'm asking the court to recall, because previous during the testimony it was established Officer Hank lied, and specific to regard to the... one second here. Let me bring it up in my notes.
Your Honor, this is blatant defamation at this point.
It's not defamation. This was something that was established through the facts of the court. Specific, I do believe, to the flames not being present, as the officer here had stated that he did not see, and specific to the evading to the police, as with Maxwell.
Your Honor, nowhere in the report is there flames listed.
Your Honor, in the report it does indeed list flames. If it would satisfy the objections of counsel, I will read directly from it. One moment. They arrived to a scene of explosion to see a building clearly blown up and in flames. While investigating, they noticed a strange male, John Jones. From the MDT report. If that satisfies their objection, could you please instruct the witness, Your Honor, to answer the question?
Mr. Seven, go ahead and answer the question, please.
Can you repeat the question one more time?
So, Officer Hank has been found to have perjured himself twice in his report. So you would say perjury counts as a lie, correct?
I mean, I guess if he answered it to his best knowledge of recollection at the moment, he was kind of in, like we mentioned, he had a pass away in the family. I haven't had a chance to speak with him or review anything, so.
All right. And could I ask?
I believe, for definition-wise, perjury is only if you answer it against your best recollection, correct?
I do believe it relates specific to what a reasonable and prudent person would know to be true based on the conceptions of the events.
Objection, Your Honor, as well. Perjury is something that is done under oath here. Hank was not under oath while writing this report.
All right, I'll rephrase. Based on what's been established in court, it is things that were untrue were put in the report by Officer Hank, correct?
I mean, I guess correct as long as it's stuff.
Perfect. And Mr. Southern, have you been admonished twice for perjury in this very courtroom?
Yes.
So, out of the 3 officers present on the scene, Officer Christopher, has he been found to have lied or perjured himself in this court?
I have no clue.
I see. I believe the answer would be no unless the prosecution wishes to object. No, perfect. So, Officer Christopher has not lied, so you would say his word would be more credible than someone who's been found to have lied in a police report or to have perjured themselves, correct?
Correct.
Objection, Your Honor. He did not perjure himself in the police report.
I said stated things that were untrue, not perjured. I said specifically perjured for Mr.
Overruled.
Southern.
Continue.
So, based on that, since Mr. Christopher Maxwell, stated that the charges were all invalid, his word on that is more credible than an officer who has perjured himself twice and then an officer who listed 2 untrue things in a police report, correct?
Correct.
Thank you so much, Mr. Southern. I love when the witnesses do my arguing. Your Honor, based on this so far, I'm waiving my right to call my own witnesses in examination. I believe just based on the state's witness and, well, lack of evidence at this point, I don't need that. So once they're done with their examination and witness calling, I'm prepared to move to closing arguments. Thank you. I'm done with you, Mr. Southern.
Prosecution, would you like your chance at rebuttaling?
Yes, Your Honor.
May approach.
Alright, Your Honor. I have a few exhibits I would like to mention here. As defense stated, as Officer 7 here stated, he does not believe the individual was evading prior to entering the vehicle. Now, if you check Exhibit 8, the suspect, or the defendant here, stand by, let me just pull it up here on my pad right here. So Exhibit 8, you can see the defendant entering the vehicle. Exhibit 9, you can see the defendant turning on said vehicle, as the vehicle was not already on. Exhibit 10 now is where I'd like to focus.
Objection, Your Honor. The vehicle actually appears to be on before he enters, in the prosecution's listed photos before he enters.
Your Honor, you can clearly see the tail lights are off in the photo. He's probably referring to the light inside of the vehicle that automatically turns on when you unlock or open a door.
Your Honor, I'm referring to the tail lights and the headlights, which appear to be on. He stated they were off in their own exhibit that shows that not to be true, and without direct testimony of Officer Hank, or without any body cam footage that the officer has already deemed can't be entered, just based off the photos they've submitted, the vehicle appears to have already been on before he enters, based on what we
Your
can
Honor,
see.
can you check Exhibit 8, please? Can you review that and tell me if you see the tail lights are on inside of Exhibit 8? Maybe counsel here is not looking at the correct exhibit.
I see in Exhibit 8 that the only light on the vehicle is the interior light, and Exhibit 10 that the headlights and taillights are on, while
Correct.
the defendant is outside of the vehicle.
So are we overruling his objection? Are we sustaining this?
Due to improper or no testimony provided by an officer, I will sustain that objection.
Okay, Mr. 7 here. Can I provide these exhibits to Officer 7, Your Honor?
You may.
Oh fuck, I crashed out. Fuck, damn. Yo, can someone hear me? Yes. Oh shit. Yeah, shut the fuck
Alright, Officer 7, you've been provided Exhibits 8, 9, and 10. In your professional opinion as an officer, do you believe the vehicle in Exhibit 8 is on?
Your Honor, I would like to motion to voir dire the witness for his, as he's saying, expert testimony on vehicles to establish his expert testimony on automotive knowledge.
Your Honor, I don't believe you need to be an expert on a vehicle to know whether the vehicle is turned on or off.
Your Honor, I believe that what he is basing on is based on knowledge of vehicle systems, and I believe he needs to be voir dired as a witness specific to not his observations, but to knowledge of a vehicle for his expertise on such a subject before his testimony could be entered on vehicle systems.
Sustained.
Thank you. May I approach the witness stand and voir dire the witness?
You may.
How are you doing, Mr. Southern? I'm just going to ask you a few quick questions to establish your automotive knowledge. Could you tell me what does the WD-20 in regards to oil refer to? And if you could please answer within a few seconds of each question to ensure nothing's being looked up.
The weight and viscosity of the oil.
Ah, very perfect, very perfect. And could you tell me what type of electrical system does the vehicle use for the tail lights?
It would be a 12-volt system.
I see, I see. And what's the make and model of the vehicle?
That's vehicle specifically. I do not know this city's term of that vehicle.
I see. Could you give a rough idea of what the make and model is, even if it's not 100% lore accurate?
I mean, it appears to be a Dodge Durango.
A Dodge Durango. I see. And are you familiar with the workings of the electrical system?
To an extent, not perfectly.
Not perfectly. So you could say that your knowledge of the electrical system and the brake and light system isn't perfect or good?
I mean, I would say it's good, but not perfect.
Good, but not perfect. What would you say your knowledge capacity is? Is it 50%, 99%, 2%? What would you say it is?
Your Honor, objection here. How many questions are we allowing defense to ask here?
I've asked less than 10 so far. I think that's a fair question, especially specific to the expertise of the knowledge to the specific system being questioned about. Could you answer the question, Mr. Southern, unless the judge is sustaining?
Let's just wrap this up in a few questions.
There you go.
I believe it's proficient.
Would you give me a percentage of your proficiency? Do you know 100%?
I wouldn't know how to give you a percentage. I mean, that would be based on what kind of vehicle and so many factors. I couldn't accurately give you a percentage.
I see. So there's a doubt to your knowledge then.
Not to my knowledge of whether it is on or off.
I see. Your Honor, I'm satisfied with his basic knowledge of the system.
Your Honor, can we proceed with the line of questioning then?
You may.
All right, Officer 7. Let's go back to what we were saying. Exhibit 8. Does the vehicle appear to be turned on or turned off? In your professional opinion, of course.
In my opinion, it appears to be off.
Okay. Exhibit 9, with the defendant inside of said vehicle, do you believe the vehicle is now turned on or off?
I believe it is turned on due to the headlights and hands on the steering wheel.
Do you see, so what else do you see in this picture here that's happening?
Give me one moment to enlarge the photo. I see that at this time, Officer Hankson has pulled his taser, which kind of indicates to me that the vehicle is turned on and attempted to move.
Okay. Now, I want you to look at Exhibit 10 here. Do you know what's happening here in Exhibit 10? What do you think is going on, and can you explain to me what's happening?
I believe that is him attempting to enter the vehicle.
So Exhibit 10 takes place.
Re-enter the vehicle. I would have to, like I said, I would have to review body cam to be sure.
Okay. So Exhibit 10 takes place after Exhibit 9. That provides you any knowledge.
The exhibits aren't numbered. I don't know when you said.
I provided it in order.
Okay, give me one second. I believe that would be him trying to re-enter the vehicle.
Okay, so when a suspect that has been, do you know why he was trying to re-enter the vehicle, or what happened, like, to him how did he get ejected from the vehicle, and how did he try to re-enter?
I believe he was tased out by Officer Hankson and then attempted to re-enter to flee again.
Okay, and in your opinion, in your professional opinion, of course, you constitute that as evading?
Yes.
Okay. So again, you did state earlier that you did not think that it was evading just prior to him getting into the vehicle because he was not told anything yet. But as he was tased out of the vehicle and re-entered, you believe at this point that this is considered evading, correct?
Yes, it would be evading at that point for sure.
Can you clarify, like, why exactly you think it's evading?
Because at this point he has been notified that has been stated today, and then he was tased out of the vehicle, which, I mean, a taser, you definitely feel a taser. That's not something you do not notice. And his window's appears to be broken in the exhibit from said taser shot, and then attempting to re-enter the vehicle would be attempting to get away.
All right, Your Honor. That's all the questions I have. Thank you.
Your Honor, since a new piece of information has been brought up, can I have a rebuttal as well?
Your Honor, objection. This is exhibits that were already provided.
But the specific expert testimony to the automotive knowledge, Your Honor, was not gone over in the cross-examination, and since it's a new piece of testimony, I should get my turn at it as well.
Sustained.
Thank you. May I approach the witness stand, Your Honor?
You may.
Officer 7, as you've stated, the first photograph that you viewed here with the tail lights off is before he enters the vehicle, correct?
Yes, I believe so, from what I can see here.
And then as they stated, the second one is after he had been tased out, when he was attempting to get back in.
The second one would be before he was tased out, and he was being warned that he would be tased out.
I'm sorry, I'm a bit confused. Before, you stated to the prosecutor when he asked that the second one with the lights on was after he had been tased out when he tried re-entering the vehicle after being tased.
That would be the third one, not the second one, in the order I have them sent to me.
I see. I was unaware of the second one. I was only looking at 8 and 10 here. So the third one then for you, you see him getting in the vehicle with the lights on, correct?
Yeah, that would be the third one.
I see. And the vehicle only moved when he was first tasered, not when he was the second time he was tasered, correct?
I have no idea, like I said, I haven't reviewed body cam or anything.
I see. But the evading occurred when he attempted to move the vehicle, and that was why he was tased, correct? You didn't just tase him for not evading?
Yeah, he was tased because he was warned if he attempted to move the vehicle, he would be tased out.
I see, and he moved the vehicle, and that's why you tasered him. I just want to get that specified.
I wasn't the one who tased him, it was Officer Hankson.
Well, was he tased for moving the vehicle and thereby evading?
Yes, he was warned that moving the vehicle would be evading, I believe.
I see. So, photo 8 here, the first one you were sent, happens before this, before the movement, and the 10th photo here, the 10th exhibit here, which is the third photo for you, happens after. Could you look at the two, and as you had stated before, evading wouldn't be simply moving a few inches. Could you tell me how far the vehicle moved? How many yards would you say the vehicle moved from?
Objection, Your Honor. This was previously asked and answered.
I don't believe it's been answered specific to the photos. The first one he was sent, Exhibit 8, and the third photo he was sent, Exhibit 10, I believe will show the exact distance that it moved. And in fact, I think it's quite clear from it, and I don't mean to testify, but that the two photos show that it did move, and as one happened before the alleged movement, and one happened
Your Honor.
after.
He is testifying right now.
Let me strike that. Let me ask the question of the witness. Based on the first photo, Exhibit 8, that you were sent, and the third photo, Exhibit 10, you were sent, and keeping in mind your two previous admonishments, does it appear that the vehicle has moved any significant amount whatsoever?
From the angle of the photos, it is hard to tell. Like I said, I would need to see body cam to...
So your answer there would be no, based on just the photos?
I mean, based on the photos, the angle, you can't see the front of the vehicle in the first photo from what I have, and obviously, without being able to see that, I can't give an accurate distance, especially with nothing there for scale.
So you would say that, based on the two photos, it doesn't appear that the vehicle is moved, from what you can tell?
Objection, Your Honor. Asked, answered.
You can tell that it is moved, but there's no way to tell how far without something being there for scale.
Get your point, Counselor.
I see. let me ask a modification of that question. Based just on those two photos that we have access to, does it prove that the vehicle moved?
Yes, you can clearly see that it is further from the sign. There's just nothing there for scale to tell how far.
I see. Would you say it's a significant amount of movement?
Objection, Your Honor. We're going back to the same question.
Again, I'm just trying to establish the distance of movement, Your Honor.
This is the 5th time answering this question, Your Honor.
Sustained, counselor. Let's get a move.
Very well. So you don't have an affirmative knowledge how far he moved?
No, I just know he was warned that if he tried to drive off, he would be chased out.
I see. And without a specific knowledge of how far he moved, can you say that he moved far enough to constitute evading?
I mean, yes, if you're told if you move at all, then we would remove you from the vehicle, then moving it would be evading.
I see. And is that what was said to him?
Like I said, I haven't reviewed to get exact words, but I believe it was something along that.
So you can't say for sure then?
No, not without being able to review.
Thank you very much, Mr. Southern.
Mr. Maxwell, you may return to your seat. Or, I'm sorry, Mr.
Abby, 7.
Sorry. Prosecution, do you have any further evidence or witnesses that you would like to call or bring to the court's attention?
Yeah, no, casual.
Okay, I'm gonna take that silence as a no.
Oh, sorry. Can you, Your Honor, can you repeat that?
Do you have any more evidence or witnesses that you would like to bring to the court's attention?
Not at this time, Your Honor.
Okay. Given that the defendant's counsel waived their right to any more witnesses or evidence, we'll go ahead and move into closing arguments. Prosecutor, you may take the stand.
You, Patel.
Hold on. Phone, you taking that?
Closing arguments, prosecutor, you may...
Goofy boy.
Get up there,
Yep, my apologies.
you fucking fool.
Alright, ladies and gentlemen, as you can see, we went through some fine points and principles of this case. At this time, I believe that is all that the defense is going to present on behalf of our side. Again, we believe that all this evidence is indicative to the charges that are being brought upon Mr. Jones. And we do applaud the prosecution for the rambling, but we are not presenting this case as move forward.
Your Honor, I know it's uncustomary to object during a closing argument, but is the prosecutor aware he's the prosecution and just referred to himself as rambling?
Let's move forward.
Yes, Your Honor.
Got you guys cooked, bro. Jermaine got your asses cooked. It's done, bro.
Mr. Capone, do you have any other word?
Negative, that is it.
Good shit, Jermaine.
Mr. Jermaine, floor is yours.
Ah, thank you so much, Your Honor. Would you mind sitting, Mr. Capone? That's customary. Thank you. Would you mind sitting, Mr. Capone? I don't believe you're a bailiff.
He's been standing the whole time. He's fine.
Alright. Your Honor, members of the court, citizens present to view, it is readily apparent, based on the testimony of Officer Christopher Maxwell, that all of the charges are invalid, as specifically stated by him. It's apparent, as stated by Mr. Southern, that the evidence is inadmissible in court, and therefore all of the possession charges, as ruled, cannot be presented, since the evidence has been quashed. The only charge at contention is evading. Mr. Southern himself, specifically, has stated that he has no specific knowledge as to how far he moved. Therefore, it cannot be affirmed that he evaded. It is not readily apparent, the evading. There is, I think, a shadow of a doubt, and the burden of proof lies here on the prosecution and does not lie further on the defense, as the prosecution may want it to be. Now, I know they referred to their own rambling, but I do have to say I think it has made readily clear the belief by the police officers and by the state and by the district attorney's office that they believe this court is going to protect them from the rights of the citizens, and I hope that not to be the case, Your Honor. When it comes to this case, the court has four main things to consider. First, did the police officer violate the defendant's Fourth Amendment rights? As stated in federal case law, Florida v. Jardins, and what is specifically the exact situation, almost apples to apples, that happened here, that a dog sniff, when conducted, does constitute a search, with the only exception listed by the Supreme Court as a port of entry and a school, and I am not aware of the residence in question or the block being a school or an airport, nor a port given the lack of water. There was not probable cause present at the time. The dog sniff is what led to such. Thus, the dog sniff in and of itself, starting this whole thing, was unconstitutional, and even if everything hadn't been dismissed already, it would be inadmissible due to this. Second, did the police officers identify themselves, and did the suspect consent to a frisk or search as the police stated he did? As it's been made readily clear, the police have lied in their report, and at no time did they identify themselves, or did they order Mr. Jones to stop running before he got into the vehicle, nor did Jones give consent at any point to a search or to a frisk, as the exhibits presented show. Therefore, it was not fleeing, based on this and the testimony of Mr. Seven. Third, why would the police lie and violate the rights of a random bystander? It's because the officer Hank believes the end justifies the means, and that he can violate rights and lie if it results in arrest of a person who possessed drugs. First thing he stated coming onto the scene was that he didn't want to stack bodies. This is a DEA ATF thing. He is clearly a man attempting to inflate his own ego. There was no probable cause, nor was a detainment made due to a lack of reasonable suspicion, nor was any warrant present at the time. That is why Officer Hank called his dog and made it a sniff. He was too lazy to do any kind of proper detective work, and he took a shortcut. And the fourth thing, and I think the most important thing for the court to consider, is for its creation by our founding fathers. And it was created to protect the rights of its citizens through due process. And the court's decision here is clear. Does it exist now, so far after its creation, to protect the rights of the citizens from the police? Or does it exist to protect the police from the rights of the citizens? The legal arguments here are without doubt, the merits are obvious and present, and the consequences of the decision today require a more wisdom-based approach to consider its ramifications for the city as a whole. So I have to leave the court with this. Since I was quite young, a schoolboy, I've known some words of wisdom I feel could apply here. That with the first link, the chain is forged. The first speech censored, the first right forgotten, the first freedom denied, chains us all irrevocably. Those words serve as wisdom and as warning. The first time any man's freedom or rights are trodden upon, we're all damaged. Your Honor, members of the court, citizens of the state, the merits of our case and the violations of the police and their misconduct are apparent, and the court has a duty bound to it by the Constitution to uphold the rights of my client and to dissuade the police from any further misconduct by throwing their case out. And with that, the defense rests, Your Honor.
Hell yeah.
Alright, gonna call a 5-minute recess to await my final call.
Attaboy, Jermaine.
Fucking criminal.
And during our recess, I would
up,
like
man.
to post an
You already got
advertisement
caught
for
in 4K.
Rex's Diner, the only source of dino nuggies in the state of San Andreas.
Dyer, there's a cafe.
Let's fucking go. Hell yeah. Good shit. Good shit, Jermaine.
He's doing my job.
Yeah.
Anyone got food? I'm dying over here.
Nah, you're shit out of luck. You died.
John, you know how long we've been here? We
don't even
are the
wanna
last
talk
one
about it.
standing.
I don't want to talk about it.
We're going into
Even-
hour 3.
So now you gotta give us the
Yeah.
link code.
It's gonna be right on the mark
Yeah,
of 3 hours.
we
It
met
looks
the
like.
lean code. Hello? Since you know
There'll
it.
be some chicken wings for the lean code. Don.
How are you?
Yeah.
Yeah, since PD thinks you know the
Oh,
lean
I'm
code.
muted.
so
Hi,
does
how are
it.
you?
You had 20
Mr.
lean in your
Jermaine.
pocket. How'd you get it? How'd you get the 20 lean, huh?
Come
Yeah,
here.
bro. What's the ratio? Please tell me.
Yeah,
I can't wait for me and you to have a battle. You're pretty good, huh?
I am. I'm looking forward to you too. You and Capone, I think, with proper preparation.
not heard a
would
single
come
bit
back.
of it. I don't have a radio.
They kind of stuck me on this duty at
I
last
know.
minute. If I wouldn't have been stuck on this duty, I would have asked to be called up as a witness.
I'm looking forward. There's an
But I'm
outstanding
looking
case for
forward
Plu
to
Plu.
it.
I want you to take it over. I'm looking forward to a good court battle. This is the best.
Yeah, me and you will be good.
I've had quite a bit of court battles. This is the only one that I've had any true contention from. Every other one has been a breeze, and I've been doing this for 13 years.
Respectfully, I have a degree in law, and I don't really call that content. It might be the most contention you've ever got, but
Yeah.
there can be a lot more.
I'm looking
I
forward
was
to
I've
it.
sat in silence for the past 3 hours.
I was.
I don't have a
present
radio.
at the very, very end, after they had already processed it, but I didn't think it was enough presence for me to be called to the stand, so
Yeah.
didn't really want to put my input in.
I'm looking
But
forward to this.
I'm wanting a battle.
I am looking forward to it. A knife never sharpens against a dull stone, and I think you're the
Oh,
sharp
no,
stone I
sir.
need to get even better.
They didn't search you pretty good.
It's gonna be. I just wanted to talk to you about it. It's gonna be fun. I know it's gonna be fun.
Oh yeah.
'Cause, if I would have been sitting right there with some of them questions, we would have been battling, my boy. It made it a little bit easier on you.
Looking forward to this. This will make it
Alright,
interesting.
Judge is back.
Jermaine, will you, Jermaine and prosecution counsel, you meet me in my chambers, please?
Could you,
Yeah.
Sorry, I hate to
Or-
butt in. Did the verdict come through yet? I want to make sure I didn't miss it.
Not yet.
No for recess.
could you further
Appreciate that.
clarify the reasons as to why
Mr. Capone is
he should be found not guilty?
Since the evidence for the
Mr.
specific.
Mr. Hake,
Excuse
I've
me.
asked you to step out.
I just had one question for you. So I have not been here, right? I had issues, a couple up there. This is my first time back. I did not know this was going on. The evidence that was handed was completely wrong with everything like that. This entire case should be null and void. You know, I was the prime quote unquote suspect in this situation. So this entire case either needs to get null and void or retried just because I was not here.
So while I give my condolences to the things that you had going on, if the prosecution wishes to contest my ruling, they are well within their right to do so.
What'd you say?
But I ask for you to await my ruling, and prosecution or said counsel can go about what they choose to do.
I mean, I feel like this should at least continue with me not being here. You know, this entire
Shut
situation
up.
started with me, did everything with me. Without me being here, this entire case has
Yo, free my boy
nothing.
John. He did nothing wrong.
Right.
I
Like-
agree with you, but there was
Dominic,
no
quiet,
continuance
you owe me money.
filed. They could have filed a continuance. They chose
keep it
not
like
to.
that.
That's on them for their strategic.
Brother, I'm
choice.
gonna be completely honest with you. My shit that I had going on is a lot more important than that fucking guy out there.
I'm getting him.
I'm getting him away from listening in on the conversation. That's
I
why.
won't argue that with you, but again,
Fine, I
to
guess
go
I'll
back
do
to
my
court
job.
for another 3 hours, I feel would be unnecessary. I think everything that can be said has reasonably been said.
Well, I mean, with the wrong evidence being shed to light, we as PD as a whole have not had the correct try, so to speak. You know, all the evidence, exactly, all the evidence that was brought. You know what? I will gladly sit here for however long you fucking need and help out the PD in this judicial situation.
Again, Mr. Hank, while my condolences lay with you on whatever you had going on, court was announced promptly, I believe, yesterday. Could have been sooner. I'm not too sure exactly the time and date that it was announced to the public of the court date and hearing. I say wait for my ruling. If prosecution wishes to contest my ruling, or opposing or the defendant's counsel chooses to contest my ruling, they are well within their right. But to ask the ladies and gentlemen of the court, including myself and everyone else present in this room, to sit in court through another retry for an additional 3.5 hours would be completely unfair.
You know, I'm sure they'd like it. And I'm sure the only reason that they're going to get pissed is because, you know, a full-fledged fucking criminal who got caught red-handed is going to be getting a fucking payday.
Well,
again,
Officer Hank, and I don't mean to be
Sergeant.
rude, Sergeant, but this isn't Burger King. You can't have it your way. The date was posted 3 days ago. The evidence that you're saying was submitted was wrong was 5 days ago. It's been in there for 5 days. That was what was submitted 5 days ago. If the wrong
You
evidence...
realize that you subpoenaed everything, right? I sent you over everything. You received everything personally, knowing what evidence was going to be coming to light in the situation at hand.
Again, this was what I was sent. You've sent nothing personally to me. It was all sent to Gotti and then to me. You might be mistaking me for Gotti, and this was what was submitted by your attorney at the time.
Again, I do appreciate your enthusiasm to pinch in your 2 cents. The ladies and gentlemen that sat during the whole trial of this case was a whole 3.5 hours, and everyone in this room can attest to the trials and tribulations that we underwent to proceed through this court case. Again, I'm going to say for the 3rd time, I'm going to ask you to await my ruling. If the prosecution wishes to challenge that, they are within their right to do so.
Gladly.
All right, Your Honor, where were we called in here?
So he's wanting to more clarify.
I'm asking each side to clarify why your side is right in layman's terms.
So the physical evidence was already quashed per your ruling earlier. So there's no evidence that anything was taken off his person. So all the possession charges would be null and void then. So the only thing in question is the evading charge. Officer 7 stated he doesn't know how far the vehicle moved. If you don't know how far it moved, you can't quite say that that's evading. Him getting in the vehicle the first time isn't in question, because he said that the evading would not have occurred until after he first entered the vehicle. And since the only thing they seemed to have any legitimate argument for was that he disobeyed a lawful order, and that charge not being presented in the charge list for when he entered the vehicle the second time, there's no valid charge that he can be charged with based on the evidence in the testimony.
Hey, we got an issue.
I'm sorry?
Unlock the door, we got an issue.
Oh, what kind of issue?
Hank just murdered somebody in the stands.
That's
Huh?
crazy. Hank just shot someone's head. Because he said you can't.
He crashed out,
You can't talk shit.
He crashed out.
He shot.
He murdered? I don't see anyone dead.
They brought him
Blue.
outside.
He's over here.
They brought him outside.
He was escorted outside and transported.
I want his badge stripped.
It was Blue. Blue got shot.
Fucking deafened.
Oh my god.
I'm guessing it was some.
Oh,
was it
hey,
something
I'll speak
personal?
to it, like,
I
Yeah,
know.
yeah.
Listen. If it was something personal, I wouldn't worry about
It was Hank trying to explain why he wasn't here. Obviously, he had very serious family issues going on, and Plu was talking shit.
Yeah.
No, but he was talking shit too, bruh. So
Yeah,
don't be like that.
he came out and said something along the
Yeah.
lines of don't spend all the money in one place. I was all the way over here because I guess I'm supposed to be protecting the judge. I don't know what the fuck they put me a bailiff for. I heard him say something about don't spend all the money in one place, and then he got too far away from me to even hear the rest of the conversation. I heard Plu's side of it, of him just saying you should have been here and shit.
Yeah, no, Plu just said like
Very traumatized from these
Once upon a
events.
time.
like this all could have been a
Yeah, Plu said this all could have been avoided if you would have done your job right, which
which is fair.
So he
Which
didn't
is
say
fair, though.
he didn't say something about the family or anything like that.
Well, he
No, he
said
never
you
said-
should have been here if it was that
No,
important
bro,
to
I'm
you,
about
and I'm
to
pretty
see
sure
you.
Hank said something along the lines of why he wasn't here. I couldn't hear Hank.
Once upon a time, there was a pretty draft, and that draft was so tall.
Capone, are you available?
I got the rundown of what happened. Do you want me to see if I can talk to Plu into not pressing charges against Hank?
Yeah, man, he's going through a lot, bro. And then
let's
Plu was talking bad about him and shit. So you know how you can kind of
Hold on,
crash
gentlemen.
out.
Let's discuss this after this.
Yeah, after.
Yeah, for sure.
Okay. So let me provide my side of this now. While I hate to agree with the defense here, unfortunately, I'm gonna be blunt here. The DA is not very competent, and provided the incorrect evidence. So that did lead to the evidence being thrown out. So I guess we can agree on that part here. Now, in regards to the evading, Seven did clearly mention, and this is not a discussion, it's never changed at any point, that he did agree that the suspect was evading. It was mentioned again in his testimony that when he got out of the vehicle, he did attempt to get back in the vehicle again after being tased already. So this is again something that was mentioned on the stand. As of this time, I do believe he should be charged with that evading charge at the minimum.
As well, per the evading charge, before he could be even told that he was detained, he did flee from Officer Hank once he saw the dog was, being a little hostile.
Yeah, but
that was already dismissed.
yeah.
And specific to that point, I would go to
Why was that dismissed? Hold on for a second. I'm sorry. Why was it dismissed?
Because both witnesses agreed that it wasn't
May I have the
evading.
lawyer
And,
at the front door,
well,
please?
one witness said it wasn't evading at all, and Southern is saying it was only evading after he got into the vehicle and after he was given his first verbal order. Because at that point, he hadn't been detained or given a verbal order whatsoever.
I'll take that lightsaber.
Got
But
you.
specific to the point that I'm trying to make here for the evading, since one witness, Officer Maxwell, is saying that it wasn't evading at all, and Mr. Southern, the only counterpoint to that, is saying that it was evading, even despite the discrepancies between not much in fact, I can't even tell any movement between the two photos, and him stating that he couldn't discern the movement distance, which without that, if you don't know how much the person moved, if they moved at all, you can't really say they're evading. You have to balance their two words, the word of someone who was told to be truthful the whole time and someone who's been admonished twice for perjury, and I feel that there is at least a 6% doubt to dismiss the charge, but I think it goes much further than 6%. I'd say probably with 80% certainty that Maxwell's word, the one who's not lied or perjured, is more valid than the one who's perjured twice. 7 would be 7.
Yeah, of course, I agree. And where was Southern, committing perjury? Because remember, you stated because of his side of the story, it didn't match up Hank's report. Now Seven doesn't have anything to do with the report that Hank provides. He's just giving his side of the story on when he was at the scene. He can't say, looking at Hank's
again, those two things have already been ruled on.
To save some time
and
here,
since you agreed with me on that, I think we're all in agreement that all the charges are invalid.
Not all the charges. I said the evidence.
Your second chair
charges.
just agreed with me on my point about the evading.
When did he agree with you on that?
He just said I can agree with you on that, but when did Seven perjure himself?
He's referring to the running in the alley.
Yeah,
he's
yeah,
saying he agree with you on that.
you know, when the detainment and stuff like that.
Where we are currently, as I said, I do agree with the evidence. The evidence was, again, not a lot of competency there, so I can't really comment on that. But in regards to the evading, the Officer 7 did agree that the suspect was evading, and I believe you probably see that in the pictures provided as well, Your Honor.
And again, the basis is
I'm sorry,
beyond.
repeat that last little bit. I'm sorry, it cut out.
I said you would probably see that in the pictures provided as well, Your Honor. I think the defendant was in fact evading.
Again,
Are you saying he was or was not? In fact,
he was.
Again,
my biggest thing here is it considered evading if he is not formally detained or was under the impression that he was speaking to anyone law enforcement involved? They weren't.
But he was tased though. He was tased out of the vehicle, and then he still tried to get back in the car again. What do you mean? Like, is a taser not enough for you to realize that you're at this point being apprehended by police? I mean, I'm sure that shock.
Yeah, but
has
the
gotta mean something,
evading
right?
allegation per 7 comes before the
All right,
taser.
give me a
and
few
after
minutes to come up with my complete ruling, and we'll move from there.
Yo, man, the 5 minutes are over with.
Appreciate it,
Yo,
gentlemen.
5 minutes, bro. Come on, let's go.
Yeah, he's gonna be coming on in a second.
Alright, bet.
Mr. Capone.
Catching shit, bro.
Out. Outer, I'm putting you in cuffs
Guys,
right
the
here.
court's done, bro. Y'all already got cooked. I'm smoking
Outer.
a pack right now, bro.
Everybody waiting. The judge is just
And
deliberating.
then
Maybe I don't.
Move your butt. Thank you.
That's crazy.
The prosecutor has agreed with me that the charges
in
are
cuffs,
invalid.
thank you.
So
Sounds good.
I guess I convinced the
Bro's
prosecution.
acting like he doesn't know why he's being detained. Crazy.
Yo, Chance, stop talking.
Yeah, man, why don't you try to get away from me for once instead of getting caught every time?
Bro, you never caught me, buddy.
That is an insane statement.
You know what? It's not.
Hey, Cans, get Derek out of here.
I think I have,
I need
let's
this open.
see. Oh, that's 4 different cases I've made on you where you've been arrested. Yeah, I'd be quiet.
Oh my god.
Where's
Dominic at?
Who's this one?
Said he was in here.
Charbel?
Oh, you're Charbel?
Yeah.
Hello.
Hi, Elsa.
How are you?
Good for you.
taking the
Chilling.
jail?
Oh wait, I slipped the wrong way.
Please.
Oh, Jermaine.
Who's hungry?
Yeah.
Jermaine.
I am
Come here.
hungry.
Yeah.
Have you followed my
I
purple
have
eyes yet?
nuggies and apple juice.
I don't think so.
Oh shit.
You should.
Send it to me. Email it to me.
It's already in the Arise
I think,
emails.
yeah, I think he posts it in the Arise promo like every day.
I'll have to look for it. Is it the same as your regular names?
Just Pickle Pete.
Pickle Pete.
Gaming.
Okay.
Yeah.
I'll pick.
Sorry.
I'll,
Thank you.
I'll Pete your pickle.
Okay. Okay. Okay.
Okay.
Okay. Elsa, I didn't get no food. I said I was fucking hungry. Like
I
what?
thought you was talking about.
Both, but damn, I'm hungry. She over here giving food to a guy with white hair. Like damn, Dilly ain't shit no more. Fuck Charbel. Fuck you, Charbel.
Fuck you.
You too.
All right. All right. Yep. I lost.
Alright, here you go.
Dynamo nuggets.
After this, I have to go to the food store because now I'm out.
Oh,
No, ooh is always open, so.
oh shit. All right. Everybody sit down. Everybody sit down. Sit down. Everybody sit down.
Alright, everybody
Thank
take
you.
a seat.
Everyone sit down unless you're an officer. Please.
Finally on the opposite side of the fence.
That really scared me.
Yeah, I just tripped.
Okay, everybody, I believe we're missing a few people. There they go. So, after review of the evidence, witness testimony, and the arguments provided,
On the charge of criminal possession of a weapons class 1, the court finds Mr. John Jones not guilty. On the evading charge, the court finds Mr. John Jones not guilty. Possession of a controlled substance, not guilty. Possession of a Schedule II with intent to distribute, not guilty. Based on the following. The suppression of physical evidence. The evidence was previously all quashed due to improper handling, making it inadmissible in this trial. The evading charge. Witness testimony failed to establish clear evidence of how far the defendant's vehicle moved, making it impossible to determine if evasion legally occurred beyond a reasonable doubt. The prosecution then argued that the defendant being tased clearly indicates that they were interacting with a law enforcement officer. However, this court finds that the use of force does not automatically establish lawful identification, especially given disputed testimony regarding whether the officers properly identified themselves prior to escalation. Witness credibility. The testimony presented in court revealed one truthful witness while another was admonished twice for perjury, severely damaging the prosecution's case and raising doubts about the reliability of their evidence. With that, court is adjourned.
Your Honor. Oh.
Elsa, you laughed about my dogs barking. I swear I'm gonna fight you.
Your Honor, one final matter. Bail was made in the amount of 119,000. Given that the defendant appeared lawfully, it will be returned to him by the LSPD. Could we get that handled now, Capone?
Stand by. That's what I was gonna ask the judge.
Could
you restate that amount?
That was 119,000. He was originally fined over that amount by 25,480, but the amount he was fined over the 119 was returned, so only the 119 is outstanding.
Okay. We'll make sure that 119,000 is returned, and I will be down to PD to adhere to make sure that happens as soon as possible.
Thank you. Since we have all necessary parties present, could we go down there now to handle that?
Absolutely. Does anyone have any questions, comments, or...
Come on, we gotta go get your 119 coming close.
I don't know how we proceed here. So we're returning the bail, correct? And then we're dropping the charges, right? If we're moving it from his profile?
That's not... Oh, yeah. Sorry, my bad.
The charges will be dropped. He's found not guilty on all charges. The 119,000 that's outstanding will be returned to Mr. Jones, and that'll be that.
Alrighty.